Kaliang, when the participants are in, we shall start.
It started.
Okay, good morning. Ladies and gentlemen, this is the first episode of APAA's Trademark Caravan. The Trademark Caravan is an initiative conceptualized by our immediate past president, Mr. Hirohito Kasunuma, during his presidency. So we have invited Mr. Kasunuma to give us a welcome address today. The bio of Mr. Kasunuma, as well as all the speakers of today, are detailed in the webinar invitation, so I will not repeat the information here. Without further ado, let's welcome immediate past president, Mr. Hirohito Kasunuma, to give us a welcome address. Mr. Kasunuma, please.
Okay. Thank you, Rebecca. Dear participant, dear member, dear guest, and my friend, and all the panelists, thank you for coming to join the first Trademark Caravan. Of course, you already know the APAA, but let me just roughly touch the establishment of this Trademark Caravan. The APAA is a non-professional, non-political organization, and one of the objects is to foster the tie of the between the members, and we will do anything and by any occasion try to strengthen our friendship, and through that the final object is to facilitate the development of IP in Asian region. So APAA now has the Trademark Caravan. The idea is that you can see so many international speakers, and of course the local participants can discuss the various matter about the trademark. So the Trademark Caravan is a project, kind of the providing occasion to have such an opportunity in various countries and to exchange the IP knowledge, and then through this we will finally bottom up the IP level of the in Asian region. So I'm so glad we had finally to launch to the first step of this Trademark Caravan. Actually, last year we are affected by the COVID-19, so we have no opportunity. But today, even though it is through this electronic webinar, not in person, but we have the first Trademark Caravan webinar. And so we have so many famous international speakers, and we are very lucky to have our guests. I believe they will give you some keynotes after my speech, and so I have to end my opening speech. I welcome everybody here, and I hope you can enjoy and have a fruitful time to this Trademark Caravan. Thank you. Thank you for coming.
Thank you, Mr. Kasunuma. And now, originally, we have invited a very distinguished guest of honor, His Excellency Mr. Suon Vichea, Director of the Department of IP and advisor to the Cambodia Ministry of Commerce, to give us a keynote address. Unfortunately, His Excellency is now occupied in a high-level governmental meeting. And so Mr. Tao Rith, Deputy Director of the Department of IP, will be deputizing him and give us a keynote address on the general IP laws of Cambodia. So let's welcome Mr. Tao Rith.
Okay, thank you very much. Good morning.
Good morning.
Mr. Hirohito Katsunowa, immediate past president of APAA. First of all, on behalf of Excellency Pansor, Minister of Ministry of Commerce, and also Chairman of National Committee of Intellectual Property, and on my own behalf, I would like to express my sincere thanks to your presence in this event. And it is also my great honor to be invited to deliver the opening remark for Asian Patent Attorney Association, APAA, webinar series, trademark Caravan 2022, highlight on Cambodia today. Taking this opportunity, I would like to express my deepest compliment and most profound gratitude to Asian Patent Attorney Association and Department of Intellectual Property of Ministry of Commerce for cooperation to make such an important event happen today. As we are aware, the trademark Caravan is an initiative of APAA traveling around the Asian jurisdiction and focus on the trademark law and practice of one jurisdiction and time. The first stop of the trademark Caravan in Cambodia. So the main purpose is to share about practical information about registration of trademark as well as enforcement of trademark right in Cambodia. Cambodia IP legal framework is still in the stage of development, and enforcement of IPO remain problematic. Nevertheless, there are procedures in place regarding registration and enforcement of IPO, which are efficient and can be used by anyone who wish to protect their right in Cambodia. Cambodia is also a member of the Paris Convention for Protection of IP, which take precedent over domestic Cambodian regulation in case of conflict between the two. In addition, Cambodia is a member of WIPO Convention, Agreement of Trade-Related Aspect, Intellectual Property Treaty, and the Convention on Biological Diversity in 2015. Cambodia also member of a party of Madrid Protocol, which make it possible to protect a mark in large number of countries by obtaining an international registration that has effect in each of designated contracting party. Cambodia law protect trademark, Swiss mark, collective mark. It defines trademark and visible sign capable of distinguish the goods or service of enterprise. It means sound, taste, smell, or other non-visible element could not be registered as a trademark under Cambodian law. Even though Cambodian law does not mention 3D trademark, it is still possible to register three-dimensional dimensional trademark in Cambodia as long as they meet the requirement of distinctiveness. Currently, there are so many trademark registration in domestic, and there are also international trademark registration, and there are 8 GI mark for domestic mark and for foreign mark. Every day, new product and idea are created, thus making innovation and new idea important in the business. So it is very important to protect intellectual property, the right to create, the market this product. However, intellectual property in the business is overlooked in Cambodia. In order to protect this intellectual property right in the current business environment to promote competitive advantage for all business, it is crucial to give strong protection to the disclosure of their innovation to public. Cambodia and other countries alike has implement and protect the intellectual property of national and international right holder in order to enhance the private sector development, promote economic development, attract foreign direct investment in order to create more jobs and improve the living standard of Cambodia people, especially in alignment with Cambodia obligation under international framework and Asian Intellectual Property Action Plan. Taking this important opportunity, I would to inform all of you that Cambodia is a small country with a constant, growing, and dynamic domestic market of about 16 million people. The Kingdom of Cambodia has emerged as one of safe place and more attractive economy in Southeast Asia. Cambodia has a highly receptive government with political stability, macroeconomic stability, sound transparency, and predictable legal framework. And average through her membership of ASEAN since 1999 and her membership of World Trade Organization since 1904. The country has made progress in integrating in emerging economy into regional and global trading system. The Royal Government of Cambodia has identified for main engine to full economic growth, and those include garment, textile and footwear, construction, tourism and agriculture, with labor together with plenty of resource and receptive government as approved in 2015. Cambodia attract FDI from a foreign country with total capital of investment of US more than 331.5 million, and among those 40% has been invested in industry sector. Cambodia has also adopted digital economic and society policy to catch up with the 4th industrial revolution, a trend to increase economic efficiency and to provide the benefit for Cambodians from the digital transformation. It is accepted that IP protection is one of the main factors that spur the technology development. Besides, it also has a role to play in many other sectors, namely agriculture, environment, industrial, public health, etc. In fact, the Royal Government of Cambodia has prepared a strategic plan to action plan to promote development of intellectual property through a number of important laws such as law concerning trademark, trade name, and act of unfair competition, law on GI, law on copyright and related right, law on patent, utility model certificate and industrial design, law on patent variety protection. Through small and medium enterprise and agro-industrial integration into regional and global production chain to develop the national economy. In addition, Cambodia has already adopted a number of law and regulation related intellectual property. Those law and regulation play an important role in protecting and enforcing intellectual property right more effectively. Department of Intellectual Property, as a head of a Secretariat of National Committee of Intellectual Property, in its action plan has been planning and building law and regulation related IP remaining in Cambodia obligation under the framework of World Trade Organization and the framework of further regional economic integration. Today, webinar is very important, and I hope that all of you who are present at this webinar has gained a wider range of benefit and knowledge related to intellectual property, especially to be used as a capital and expansion and development. Make your own business effective and in the field of intellectual property. Finally, I would like to extend my deep gratitude to Excellency, distinguished guests, ladies and gentlemen, for taking the time to attend this webinar. And may I wish you the four gems to Buddhist blessing of longevity, nobility, health, and strength. Thank you very much.
Thank you very much, Deputy Director Tao. Now we have come to the presentation sessions of today. There will be 4 main sessions, and if you have any question for the speakers, please type that into the Q&A section. You can find the Q&A button at the bottom bar of the webinar. So Mr. Tao will now be speaking to us about new developments of trademark laws of Cambodia. Mr. Tao, please.
Okay, thank you very much. So I would like to inform that my slide I speak in Khmer because I have my colleague to translate, to interpret for all of you. Okay, សូមអរគុណចំពោះការអញ្ជើញខ្ញុំមហាកិត្តិយសដែលបានអញ្ជើញចូលរួមនៅក្នុងសិក្ខាសាលាដែលមានសារៈសំខាន់នេះ
So do you hear me? Can I testing with some translation? Do you hear me, Rabika?
Tiny.
Yeah, we can hear you, Mr. Lash, but the voice is a little bit low. Can you speak louder when you interpret? We can hear Mr. Tao very clearly.
Okay, then. So please be wait then. So do you hear me very well right now?
Yes, it's better.
Okay, so first of all, he would like to say thank you for the organizer, which is invited him to be a guest speaker for this very important seminar.
Okay. Okay. ប្រធានបទថ្ងៃនេះដែលខ្ញុំចង់បង្ហាញអាដាមលោកស្រីគឺមាន10ចំណុច
So today I'm going to talk about 10 content for everyone.
ទី1តេតិននឹងប្រវត្តិនាយកដ្ឋានកម្មសិទ្ធិបញ្ញា
The first time we are going to talk about history of Department of Intellectual Property.
ទី2តេតិនទៅនឹងរចនាសម្ព័ន្ធរបស់នាយកដ្ឋានកម្មសិទ្ធិបញ្ញា
Second, we are going to talk about structure of Department of Intellectual Property.
ទី3តេតិននឹងទូនីតិភារកិច្ចរបស់នាយកដ្ឋានកម្មសិទ្ធិបញ្ញា
The third, talking about the role and responsibility of Department of Intellectual Property.
ទី4តេតិនទៅនឹងនីតិវិធីនៃការចុះបញ្ជីម៉ាក
And fourth, talking about the mark registration procedures.
ទី5តេតងទៅនឹងគណៈកម្មការជាតិនៃកម្មសិទ្ធិបញ្ញា
Fifth, I'm going to talk about the National Committee for Intellectual Property Right.
ទី6តេតិនទៅនឹងenforcement body.
Fifth, we are going to talk about enforcement body.
ទី7តេតងទៅនឹងក្របខ័ណ្ឌច្បាប់
Seven, talking about legal framework.
ទី8តេតងទៅនឹងសមាជិកភាពនៃកិច្ចព្រមព្រៀងអន្តរជាតិ
And also fifth, talking about the member of the international agreement.
ទី10ទី9តេតងទៅនឹងបញ្ហាប្រឈមសំខាន់ៗ
Last but not least, I'm going to talk about the key challenges.
ចុងក្រោយទី10គឺតេតងទៅនឹងផែនការនាពេលអនាគត
And last, talking about the future plan.
ចំណុចទី1គឺបើនិយាយអំពីនាយកដ្ឋានកម្មសិទ្ធិបញ្ញាយើងចាប់ផ្ដើមមាននៅកម្ពុជានៅឆ្នាំ1991
If we are talking about the history of Department of Intellectual Property, it was invented in 1991.
កាលនោះយើងមានតែពីរការិយាល័យទេ
At that time, there are two offices.
គឺការិយាល័យតាក់ទងបរទេសនិងការិយាល័យកម្មសិទ្ធិបញ្ញា
It was Office of Administration and Dissemination Office.
ទោះបីយើងមានថាឈ្មោះកម្មសិទ្ធិបញ្ញាប៉ុន្តែយើងអនុវត្តតែ trademark មួយទេ
Even it was intellectual property perspective, but it is dealing on only one trademark.
ក្រោយមកនៅឆ្នាំ1997យើងបានបង្កើតទៅជានាយកដ្ឋានយើងមានពីរការិយាល័យ
Then it will be upgraded to department in 1997. There were two offices.
គឺការិយាល័យចុះបញ្ជីម៉ាកនិងការិយាល័យរដ្ឋបាល
It called Office of Administration and Trademark Registration.
សូមអនុញ្ញាតទៅបន្តទៅ slide ផ្សេងទៀត
May I talk? May I move to the next slide then?
នៅឆ្នាំ2008នាយកដ្ឋានកម្មសិទ្ធិបញ្ញាបានបង្កើតរហូតដល់6ការិយាល័យ
So
2008
in 2008, department has been created 6 euros. 6 euro.
ទី1យើងមានការិយាល័យចុះបញ្ជីម៉ាក
Yes, Office of Trademark Registration.
ទី2យើងមានការិយាល័យក្រោយចុះបញ្ជី ទី3យើងមានការិយាល័យវិវាទយើងមានការិយាល័យរដ្ឋបាលយើងមានការិយាល័យ GI ហើយនិងការិយាល័យសហប្រតិបត្តិការកិច្ចការច្បាប់
Yeah, so those 6 of Bureau, trademark registration, post trademark registration, litigation, administration, dissemination, Bureau of GI and Trade Secret, and Corporation Legal Affairs.
បន្តមកទៀតនៅឆ្នាំ2014យើងមានការិយាល័យរហូតមកដល់បច្ចុប្បន្ននេះយើងមានការិយាល័យរហូតដល់10
So since 2014, and the Department of Intellectual Property has been extended the bureau until right now there are 10 bureau.
ទី1យើងមានការិយាល័យចុះបញ្ជីម៉ាកទី2ការិយាល័យក្រោយចុះបញ្ជីទី3យើងមានការិយាល័យវិវាទទី4យើងមានការិយាល័យរដ្ឋបាលទូទៅទី5យើងមានការិយាល័យ GI និង Trade Secret ទី6យើងមានការិយាល័យសហប្រតិបត្តិការនិងកិច្ចការច្បាប់ទី7យើងមានការិយាល័យព័ត៌មានវិទ្យាទី8យើងមានការិយាល័យអប់រំនិងបរិបទទី9យើងមានការិយាល័យចុះបញ្ជីម៉ាកអន្តរជាតិហើយក្រោយចុងបញ្ចប់នេះយើងមានការិយាល័យ IP policy គឺគោលនយោបាយកម្មសិទ្ធិបញ្ញា
So the last one has been make up one more is the Bureau Office of IP Policy. So as I mentioned previously, there are 9 bureau, and up currently there are 10, including IP Policy Bureau.
សូមអនុញ្ញាតបង្ហាញជូននៅរចនាសម្ព័ន្ធរបស់នាយកដ្ឋានកម្មសិទ្ធិបញ្ញាបាទអញ្ចឹងដូចខ្ញុំបានរៀបរាប់ហើយខ្ញុំមិនបាច់និយាយច្រើនទៀតទេយើងបាននិយាយរួចហើយនេះគ្រាន់តែជារចនាសម្ព័ន្ធដែលសង្ខេប
As you have seen so much possible. From a slide going. Okay, so as the I already mentioned about each office of intellectual property. So this is the talking about the organizational chart of our department. So there are 3 different level. So level of director, deputy director office, and grassroots office then. So department level, office level, and staff level then.
ឥឡូវសូមអនុញ្ញាតបង្ហាញជូននៅទូនីតិនិងភារកិច្ចរបស់នាយកដ្ឋានកម្មសិទ្ធិបញ្ញា
So I'm going to talk about role and responsibility of a Department of Intellectual Property.
នាយកដ្ឋានកម្មសិទ្ធិបញ្ញាមានតួនាទីដូចជាចុះបញ្ជីម៉ាកការពារនិងទទួលខុសត្រូវតាក់ទងទៅនឹងនាមករ trade name ហើយនឹងការប្រកួតប្រជែងមិនស្មោះត្រង់
So Department of Intellectual Property role responsibility to register, protect, to be responsible for trademark, trade name, act of unfair competition, international registration mark, and geographical identification, and trade secret and certification mark, collective mark, exclusive right, record year, and trademark renewal, and disclose information.
Assignment, affidavit of use, non-use, certificate, duplicate, certified true copy, merger, administrative settlement of IP litigation, infringement and act of unfair competition, IP evaluation of position request, apply and register mark. ចំណុចមួយទៀតគឺទូនាទីរបស់នាយកដ្ឋានដែរគឺសិក្សានិងវិភាគតាក់ទងទៅនឹងគោលនយោបាយកម្មសិទ្ធិបញ្ញាសម្រាប់អាដាមរដ្ឋមន្ត្រីក្រសួងពាណិជ្ជកម្មនិងរាជរដ្ឋាភិបាល
So besides of this, our department responsibility to analyze, study, and analyze IP policy for the high level of the ministry, said the Minister of Commerce, as the government of Royal Cambodia.
ចំណុចមួយទៀតគឺដើម្បីពន្លឿនសេចក្តីព្រាងច្បាប់និងបទបញ្ញត្តិផ្សេងៗតាក់ទិនទៅនឹងការកម្មសិទ្ធិបញ្ញា
And also another responsibility to speed and draft of law and its regulation in terms of IP field.
មួយទៀត គឺសហការជាមួយនឹងសហគមន៍អន្តរជាតិនិងអង្គការនានាតាក់ទងទៅនឹងជំនួយកម្មសិទ្ធិបញ្ញា
And also cooperate with international community and organization with regard to IP assistance.
ចំណុចមួយទៀតធ្វើជាលេខាធិការដ្ឋាននៃគណៈកម្មការជាតិកម្មសិទ្ធិបញ្ញា
And also function the main responsible for Secretariat of National Committee for Intellectual Property Rights in Cambodia.
ចំណុចមួយទៀតគឺដើម្បីសម្របសម្រួលឲ្យបានទូលំទូលាយតាក់ទិនទៅនឹងបញ្ហាកម្មសិទ្ធិបញ្ញារវាងក្រសួងពាណិជ្ជកម្មនិងក្រសួងពាក់ព័ន្ធ
And also smoothly coordinated IP mirror between Ministry of Commerce and the other related IP focal point ministries like Ministry of Science, Industry, Science, Technology, Ministry of Culture and Fine Art, and also the other relevant IP relevant stakeholder.
ការងារមួយទៀតគឺជាការងារមួយដែលតាក់ទងទៅនឹងកិច្ចសហប្រតិបត្តិការយ៉ាងជិតស្និទ្ធរវាងស្ថាប័នអនុវត្តច្បាប់គឺ enforcement body ដើម្បីការពារទប់ស្កាត់នឹងការរំលោភបំពានកម្មសិទ្ធិបញ្ញា
And also closely cooperate with the enforcement body to prevent IP infringement and unfair competition in Cambodia as well.
ចំណុចមួយទៀតគឺតាក់ទងទៅនឹងការជំរុញការផ្សព្វផ្សាយតាមមធ្យោបាយណាក៏ដោយដែលអាចធ្វើទៅបានដើម្បីតាក់ទងទៅនឹងព័ត៌មានដើម្បីការពារកម្មសិទ្ធិបញ្ញា ចំណុចមួយទៀតតាក់ទងទៅនឹងកិច្ចសហប្រតិបត្តិការរវាងក្រសួងពាក់ព័ន្ធដើម្បីជំរុញរៀបចំកិច្ចការច្បាប់ចំណុចមួយទៀតគឺជាការងារសំខាន់ទួនាទីសំខាន់ដែរគឺជាកិច្ចខិតខំប្រឹងប្រែងដើម្បីអនុវត្តនៅកាតព្វកិច្ចរាល់កាតព្វកិច្ចដែលបានចែងនៅក្នុងកិច្ចព្រមព្រៀងអន្តរជាតិដែលកម្ពុជាជាសមាជិក
So Department Intellectual Property also responsible for promoting and dissemination via any other way of information to protect IP and also coordinate with the relevant ministry to push and preparing the IP law and also show inventor to apply the obligation, provide international agreement which Cambodia is a party.
ចឹងខ្ញុំបានសូមអនុញ្ញាតដើម្បីបន្តទៅ slide ផ្សេងទៀតគឺចំណុចទី4តាក់ទិនទៅនឹង trademark registration flow chart.
So please allow me to present you about the trademark registration flow chart.
យើងបានឃើញហើយចំណុចទី1គឺចំណុចពណ៌បៃតងនេះគឺការដាក់ពាក្យស្នើសុំ trademark បាទពេលដែលដាក់ពាក្យស្នើសុំយើងពេលដែលនាយកដ្ឋានកម្មសិទ្ធិបញ្ញាទទួលបានពាក្យស្នើសុំចុះបញ្ជីម៉ាកយើងមានគេហៅផ្នែកមួយគេហៅ formality check ពេលដែល formality check បានបញ្ចប់សពគ្រប់អញ្ចឹងយើងនឹងមូទៅកាន់ផ្នែកមួយទៀតគេហៅ substantive examination ហ្នឹងគឺការត្រួតពិនិត្យម៉ាកលម្អិតពេលដែលត្រួតពិនិត្យម៉ាកលម្អិតហ្នឹងមានន័យថាត្រួតពិនិត្យមើលថាតើម៉ាកហ្នឹងវាបានផ្ទុយពីមាត្រាទី4មានន័យថាម៉ាកហ្នឹងវាពាក់ព័ន្ធទៅនឹងភាពញែកដាច់ឬញែកដាច់មានភាពគេហៅថាតើវាមានជាន់ជាមួយនឹងម៉ាកដែលបានចុះបញ្ជីហើយឬក៏វាដូចឬក៏ច្រឡំទៅនឹងម៉ាករបស់ភាគីផ្សេងទៅនឹងទុនជាតិឬក៏វាមានបញ្ហា descriptive បញ្ហា generic term អីជាដើមហ្នឹងគឺបើសិនជាញែកមិនដាច់យើងធ្វើការបដិសេធ
So the process of the
Mr. Lash, I think you're unmuted.
Oh, I'm sorry then. So the start of registration flow chart. So start from the application. So and then move to formality check, and then move to the substantive examination, which is identify a particular mark and services based on trademark criteria examination. And comply to the trademark law in Cambodia, which is different from examination level from department, which is different from level examiner until department level.
នៅពេលដែល substantive examination បានបញ្ចប់បើសិនជាម៉ាកសញ្ញាមានភាពញែកដាច់គ្រប់គ្រាន់នាយកដ្ឋាននឹងធ្វើការចុះបញ្ជីជូននៅពេលដែលចុះបញ្ជីហើយគឺយើងមាន step មួយទៀតគឺយើងផ្សព្វផ្សាយនៅក្នុង official gazette បាទយើងមានការផ្សព្វផ្សាយរួចរាល់ពេលនោះយើងមានពេលសម្រាប់90ថ្ងៃដើម្បីឲ្យភាគីពាក់ព័ន្ធធ្វើការប្រឹងបន្ទាត់
So after substantive examination, it will be result and issue the letter to applicant register or not register. If register, it will be go on registration because of the mark has been distinguished from the other enterprise mark, and then last step is the official gazette publishing, and finally opposition.
ខ្ញុំជឿជាក់ថានីតិវិធីរបស់កម្ពុជាហាក់ដូចជាមានភាពប្លែកបន្តិចទាក់ទិនទៅនឹងការចុះបញ្ជីហើយនឹងការប្រឹងជំទាស់ចំពោះកម្ពុជាគឺការប្រឹងជំទាស់ធ្វើក្រោយការចុះបញ្ជីតែនៅប្រទេសភាគច្រើនការប្រឹងជំទាស់គឺមុនការចុះបញ្ជី
I believe that the registration process in Cambodia is more complicated. It might be different from the other country. Opposition after registration, and the other country opposition before registration.
សូមអនុញ្ញាតបន្តទៅ slide ផ្សេងទាក់ទិនទៅនឹង flow chart នៃការចុះបញ្ជីម៉ាកអន្តរជាតិ
Allow me to go to another perspective of international mark registration.
បាទចំណុចទី1នេះគឺចំណុចខៀវនេះគឺអ្នកដាក់ពាក្យស្នើសុំអាចដាក់ពាក្យមកគេហៅថាអាចជ្រើសរើសមកដាក់ពាក្យមក Office of Origin ដែលយើងហៅកាត់ថា OO ពេលនោះពេលដែល Office of Origin ទទួលពាក្យហើយនឹងបញ្ជូនទៅអង្គការកម្មសិទ្ធិបញ្ញាពិភពលោកក្នុងករណីដែលអ្នកដាក់ពាក្យស្នើសុំសម្រាប់ចិត្តជ្រើសរើសការពារម៉ាករបស់ខ្លួននៅប្រមាណប្រទេសអញ្ចឹងយើងធីកទៅហើយអង្គការវាយពោនឹងបញ្ជូនទៅតាមសំណើរបស់អ្នកដាក់ពាក្យស្នើសុំ
So this is the international mark registration flow chart. There are three processes. So the first process is applicant apply to the Office of Origin, which is called OO, and then apply to the WIPO for your registration and how many countries do you want to register, and then WIPO will assign this application to the Office of Contracting Party and Office of differences Contracting Party.
ហើយឆ្លៀតឱកាសនេះខ្ញុំក៏សូមអនុញ្ញាតបង្ហាញជូននៅការចុះបញ្ជី GI Geographical Indication គឺរហូតមកដល់បច្ចុប្បន្ននេះកម្ពុជាយើងមាន GI ចំនួន 4 គឺ local GI ចំនួន 4 បានចុះបញ្ជី ទី1គឺស្ករត្នោតកំពង់ស្ពឺទី2យើងមានម្រេចកំពតទី3យើងមានក្រូចថ្លុងកោះទ្រង់ទី4យើងមានមណ្ឌលគិរីហានីឃុំព្រៃទឹកឃុំព្រៃបាទហើយយើងនឹងមានសក្តានុពលទំនិញ GI បន្តទៀតដែលយើងកំពុងតែសិក្សា
So this is the registration of a particular mark which is called GI identification. So in Cambodia there are 4 main local GI which is called Kampong Spư palm sugar, Koh Trong Pamelo, Mandul Giri Haniwa, and Kampot pepper. And we are going to register a particular potential GI product in coming soon.
បន្តមកទៀតសូមអនុញ្ញាតបង្ហាញជូនអារម្មណ៍លោកស្រីនៅគណៈកម្មការជាតិកម្មសិទ្ធិបញ្ញាសួរថាហេតុអីបានជាយើងមានគណៈកម្មការជាតិដោយសារអីដោយសារប្រហែលជាអស់លោកស្រីធ្លាប់បានដឹងហើយគឺកម្ពុជាយើងមានវិស័យកម្មសិទ្ធិបញ្ញាហ្នឹងមិននៅក្នុងដំបូងតែមួយទេយើងមានក្រសួង3សំខាន់ពាក់ព័ន្ធទទួលបន្ទុកផ្នែកកម្មសិទ្ធិបញ្ញានេះឧទាហរណ៍ដូចជាក្រសួងពាណិជ្ជកម្មយើងទទួលបន្ទុកផ្នែក trademark GI trade secret ជាដើមចំណែកក្រសួងមីស្ទីយើងមានការទទួលខុសត្រូវទៅលើប្រកាសនីយបត្រតកម្ម industry design ជាដើមឡាហើយក្រសួងមួយទៀតនោះគឺក្រសួងវប្បធម៌វិចិត្រសិល្បៈលោកទទួលខុសត្រូវទៅលើការងារស្នាដៃសិល្បៈសិទ្ធិអ្នកនិពន្ធសិទ្ធិបហែលជាដើមបាទនេះហើយជាហេតុផលដែលកម្ពុជាសម្រាប់ចិត្តរាជរដ្ឋាភិបាលសម្រាប់ចិត្តបង្កើតគណៈកម្មការជាតិកម្មសិទ្ធិបញ្ញាដើម្បីគ្រប់គ្រងធ្វើយ៉ាងណាបង្កភាពងាយស្រួលជាពិសេសទៅដល់ដៃគូសហការនានាលើពិភពលោកដើម្បីតាក់ទងទៅនឹងការផ្ដល់ជំនួយជាដើមគឺលើយ៉ាងណាគឺមាន focal point នៅក្រសួងពាណិជ្ជកម្មដើម្បីងាយស្រួលបាទ
So because of the IP different functionality and administration in Cambodia, so the government try to form the committee to supervising of the IP function. There are 3 main ministries which is administration on IP. The first one is Ministry of Commerce as the chairman, Ministry of Industry, Science and Technology vice president, and secretary. I'm sorry, and vice president as well, vice chairman as well, Ministry of Culture and Fine Art. So those 3 key function administration in charge different IP perspective as Ministry of the Commerce in charge of trademark service, including GI, so on and so forth, and Ministry of Science and Industry and Technology and Industry Technology in charge of or function on patent industry design perspective, and Ministry of Culture and Fine Art, in charge of science, art, music, composer, so on and so forth. And because of different ministry in charge of IP administration, so in order to be working with external stakeholder in IP in one window services, so the government appoint the Ministry of Commerce to be one window service as the Secretary of Intellectual Property in Cambodia.
ទៅឆ្នាំរហូតដល់ឆ្នាំ 2008 គណៈកម្មការជាតិបានពង្រីកខ្លួនរហូតទៅដល់ 14 ក្រសួងដែល ខ្ញុំសូមបញ្ជាក់ឲ្យស្រាច់តែម្ដងគឺរហូតមកដល់បច្ចុប្បន្ននេះគឺថ្មីនេះគឺមានរហូតដល់17ក្រសួងដែលខ្ញុំបានរៀបរាប់នេះបាទទី1មានក្រសួងពាណិជ្ជកម្មជាលោកជាប្រធានអាដាមរដ្ឋមន្ត្រីជាប្រធានរដ្ឋលេខាធិការក្រសួងមីស្ទីនេះជា Vice Chairman ជាអនុប្រធានរដ្ឋលេខាធិការរបស់ក្រសួងវប្បធម៌គឺជាអនុប្រធានរដ្ឋលេខាធិការរបស់ក្រសួងសេដ្ឋកិច្ចនិងហិរញ្ញវត្ថុក៏ជាអនុប្រធានដែរអញ្ចឹងទី5យើងមានតំណាងទី5យើងមានតំណាងរបស់គណៈរដ្ឋមន្ត្រីទី6យើងមានតំណាងរបស់ក្រសួងមហាផ្ទៃទី7ពីក្រសួងព័ត៌មានទី8យើងមានពីក្រសួងទូរគមនាគមន៍និងប្រៃសណីទីយើងមានក្រសួងសុខាភិបាលទី10យើងមានក្រសួងកសិកម្មទី11យើងមានតំណាងក្រសួងបរិស្ថានទី12យើងមានតំណាងក្រសួងយុតិធធម៌យើងមានតំណាងក្រសួងអប់រំយុវជននិងកីឡាជាដើមហើយទី14យើងមានតំណាងពីក្រសួងទេសចរទី15យើងមានតំណាងពីក្រសួងការបរទេសនិងកិច្ចសហប្រតិបត្តិការអន្តរជាតិទី6តំណាងពីក្រសួងការងារបណ្ដុះបណ្ដាលជីវៈហើយទីបញ្ចប់ទី17នេះគឺយើងក៏មានតំណាងពីក្រសួងកិច្ចការនារីផងដែរនេះត្រឹមឆ្នាំទៅមិញឆ្នាំ2021យើងមានរហូតដល់17ស្ថាប័នជាសមាជិករបស់គណៈកម្មការជាតិកម្មសិទ្ធិបញ្ញា
So because of the national committee has been extended their own work and responsibility relevant to the IP, so this national committee has been nominated another ministry. Okay, so until right now there are 17 ministry. Okay, so even the key ministry, Ministry of Commerce, Industry, Science, Technology, and Culture, but there are 14 relevant ministry are included in the ministry in order to implement the IP perspective in Cambodia to be grow and active.
បន្តទៅទៀតអនុញ្ញាតសូមខ្ញុំសូមបង្ហាញជូននៅទូនទីនិងភារកិច្ចរបស់គណៈកម្មការជាតិកម្មសិទ្ធិបញ្ញាគឺចំណុចទី1ធ្វើជាបកគល point ចំណុចកណ្ដាលនៃការសម្របសម្រួលតាក់ទិនទៅនឹងកិច្ចសហប្រតិបត្តិការ bilateral ឬក៏ multilateral តាក់ទិនទៅនឹងកម្មសិទ្ធិបញ្ញាជាមួយនឹងប្រទេសផ្សេងហើយនឹងអង្គការអន្តរជាតិនានាទី2តាក់ទិនទៅនឹងការសម្របសម្រួលរាល់កិច្ចការដែលពាក់ព័ន្ធទៅនឹងបញ្ហាកម្មសិទ្ធិបញ្ញារវាងក្រសួងពាក់ព័ន្ធចំណុចមួយទៀតគឺតាក់ទងទៅនឹងកិច្ចសហប្រតិបត្តិការក្នុងការពន្លឿនការរៀបចំសេចក្តីព្រាងច្បាប់និងបទបញ្ញត្តិផ្សេងៗតាក់ទងទៅនឹងកម្មសិទ្ធិបញ្ញាដើម្បីអនុវត្តកិច្ចព្រមព្រៀងអន្តរជាតិនានាចំណុចទី1ទៀតតាក់ទងទៅនឹងការទទួលនិងការប្រើប្រាស់ជំនួយtechnical assistance បច្ចេកទេសតាក់ទងទៅនឹងកម្មសិទ្ធិបញ្ញាពីបណ្ដាប្រទេសផ្សេងនិងអង្គការអន្តរជាតិនានាចំណុចមួយទៀតដែរគឺតាក់ទងទៅនឹងកិច្ចសហប្រតិបត្តិការរវាងក្រសួងពាក់ព័ន្ធដើម្បីផ្សព្វផ្សាយច្បាប់និងបទបញ្ញត្តិនានាការតាក់ទងទៅនឹងកម្មសិទ្ធិបញ្ញាទៅសាធារណជនមន្ត្រីអនុវត្តច្បាប់ទៅសិស្សនិស្សិតនៅក្នុងស្ថាប័នអប់រំចំណុចមួយទៀតគឺជាចំណុចសំខាន់ដែរគឺតាក់ទងទៅនឹងការងារសហប្រតិបត្តិការជាមួយនឹងអាជ្ញាធរពាក់ព័ន្ធតុលាការដើម្បីទប់ស្កាត់ការរំលោភបំពានផ្នែកកម្មសិទ្ធិបញ្ញាមួយទៀតគឺជាកិច្ចសហប្រតិបត្តិការក្នុងការanalyze នៅកិច្ចព្រមព្រៀងអន្តរជាតិនានាទាក់ទងទៅនឹងកម្មសិទ្ធិបញ្ញាដើម្បីពិចារណាពីអត្ថប្រយោជន៍ពីភាពខ្លាំងភាពខ្សោយមុនដាក់ពាក្យការដាក់ពាក្យដាក់ជូនទៅរាជរដ្ឋាភិបាលដើម្បីស្នើសុំសច្ចាប័នចំណុចមួយទៀតគឺតាក់ទងទៅនឹងការធ្វើរបាយការណ៍ប្រចាំឆ្នាំស្ដីពីសមិទ្ធផលជូនដាក់ជូនរាជរដ្ឋាភិបាលយ៉ាងហោចណាស់មួយឆ្នាំម្ដង
So the NCIPR, which is called National Committee Intellectual Property Right, Role and Responsibility, to be I can say what do I want to say? So to be the under supervision of the government and so NCIPR to be a focal point to be coordinate bilateral usual cooperation on IP with the different the other country and international organization, and also coordinate to all affairs which regard to IP matter between relevant ministry, and also to make collaboration on speech and cooperation on draft law, regulation relevant to IP in order to apply the international agreement, and also receive utility and technical assistance involved IP from other country and international organization. Last but not least, its responsibility also cooperate with relevant ministry, disciplinary law, and regulation awareness pertaining to IP in public, enforcement officials, students in the education institute, and also cooperate with the other competent authority to prevent IP infringement. And also cooperate in analysis international agreement in respect of IP, consider of benefits, strong weakness before submitting to the government approval of the succession, and make the annual report on its achievement to the royal government at least per 10 per year.
Bà xong anh nhạt ở bằng hai chú nơi trong một tiết cứ tẹt tông tên nâng tháp bắn cả là quạt bạc tí muối dương biên để dụ than cầm sập bệnh nhà của sung bên chợ cám tí pi dương biên để dụ than rồi bỏ cái sung misty tí bay dương biên để dụ than sứt này cái sung để dụ than sứt này để pôn sứt bạc hái lấy cái sung bọc thọp chật sờ bát tí bốn dương biên counterfeit committee គណៈកម្មការបង្ក្រាបដេញคล้ายៗនៃក្រសួងមហាផ្ទៃទី5យើងមានអគ្គនាយកដ្ឋានកបបនៃក្រសួងពាណិជ្ជកម្មដែលពីដើមឡើយយើងហៅថាកម្មគ្រប់គ្រងបាទទី6យើងមានអគ្គនាយកដ្ឋានកយរដ្ឋកទី7យើងមាននាយកដ្ឋានប៉ូលីសសេដ្ឋកិច្ចទី8យើងមានគណៈកម្មការបង្ក្រាបការរំលោភបំពាន copyright ទី9យើងមានមជ្ឈមណ្ឌល arbitration ជាតិទី10យើងមានតុលាការ
So this is talking about the enforcement body, which is the intellectual property infringement happen in Cambodia. So there are some differences body which is involved in enforcement case. Number one, Department of Intellectual Property of Ministry of Commerce, Department of Industrial Property, Ministry of Industry, Science, Technology and Innovation, and Department of Copyright and Related Rights, Ministry of Culture and Fine Art, including counterfeit committee of the Ministry of Interior, and also the body of the implementation of control, which is called right now General Department of Consumer Protection, Competition and Fraud Supervision of the Ministry of MOC. And also including with General Department of Custom and Excise, Department of Anti-Economic Crime Police, Committee for Suppression Copyright Infringement, and also National Commercial Arbitration Center, and last, Kurt.
Chạy trên dịp bí cứ tìm mối cứ main IP law cứ miền này tha bắp để bẹp bọn tên cầm sự bệnh nhà sẵn hẳn to để một đó cứ dương miền bắp sau đây bị mát bên này chân niêm nâng ẩm bơi này cả của bị trên mình một tròn thì bây dương miền bắp sau đây bị bạc cả sau đây bắt tạ cả cắm utility model như bạn bắt nâng industrial design thì bây dương miền bắp sau đây bị cài trái tên nâng bắp sau đây bị bạc cả sau đây bắt tạ cả cắm thì 4 dương miền bắp sau đây bị sân này ôn nâng sập bả hải thì 5 dương miền bắp sau đây bị ca cột rong của tụm nam thì 6 dương miền bắp sau đây bị GI thì 7 dương miền dương mình toàn miền tế khi đã trong đời có hòm ấy miền này tha cầm tông tài trạc lại cứ chạy tông từ bắp sau đây bị trade secret nâng undisclosed information và
So this is talking about the legal framework. Okay, so there are two perspectives. So the main IP framework in Cambodia, we have law concerning mark and trade name, act of unfair competition, which is enacted in 20 February 2002, and we have law on the patent utility model certificate and the standard design 2003, and we have law on amendment of the law on patent utility model industry design November 2017, and also law on copyright related right 2003, and law on seed management and breeder right 2008, and law on GI geographical identification 2014, and last, it is not official enacted, it is under drafting stage, law on trade secret and undisclosed information.
ទី2គឺច្បាប់ដែលតាក់ទងទៅនឹងកម្មសិទ្ធិបញ្ញាមានន័យថាយើងអាចយកមកអនុវត្តពាក់ព័ន្ធទៅនឹងវិស័យកម្មសិទ្ធិបញ្ញាបានប៉ុន្តែគ្រាន់តែវាមិនពាក់ព័ន្ធផ្ទាល់យើងមានទី1តាក់ទងទៅនឹងច្បាប់ស្តីពីឱសថការគ្រប់គ្រងឱសថទី2យើងមានច្បាប់ស្តីពីការគ្រប់គ្រងគុណភាពសុវត្ថិភាពផលិតផលទី3យើងមានច្បាប់ស្តីពី compulsory license សម្រាប់សុខភាពសាធារណៈគឺអាជ្ញាប័ណ្ណបញ្ជាទី4យើងមានច្បាប់ស្តីពីគយទី5យើងក៏មានច្បាប់ស្តីពី commercial arbitration law ទី6យើងមានច្បាប់ស្តីពី cultural heritage ទី7យើងមានច្បាប់ស្តីពី commercial enterprise ទី8យើងមាន code ស្តីពី criminal procedure នីតិវិធីព្រហ្មទណ្ឌបទនីតិវិធីព្រហ្មទណ្ឌទី9យើងមាន code of civil procedure គឺនីតិវិធីរដ្ឋបវិនីដើម្បីយកមកអនុវត្តនៅពាក់ព័ន្ធនៅអ្វីដែលពាក់ព័ន្ធទៅនឹងវិស័យកម្មសិទ្ធិបញ្ញា
So Part 2 talking about the related IP law. Okay, so in Cambodia, we have law on management of pharmaceutical, the 1996, and law on management of quality and safety product and service in 2000, and law on compulsory licensing for public health 2018, and law on custom 2007, and also a law on commercial arbitration 2006, and law on protection cultural heritage 2006 as well, and law on commercial enterprise 2005, and we have another law on we have another code of the criminal procedure 2007 and code of civil procedure 2006.
ចំណុចមួយទៀតសូមអនុញ្ញាតចូលទៅដល់សមាជិកភាពរបស់កម្ពុជាទៅនឹងកិច្ចព្រមព្រៀងអន្តរជាតិនានាទី1យើងបានចូលជាសមាជិករបស់អង្គការ WIPO នៅឆ្នាំ1995ទី2 Paris Convention អនុសញ្ញាទីក្រុងប៉ារីនៅឆ្នាំ1998ទី3គឺកិច្ចព្រមព្រៀងតាក់ទងទៅនឹងកម្មសិទ្ធិបញ្ញាទិដ្ឋភាពកម្មសិទ្ធិបញ្ញាគឺ TRIP Agreement ទី4យើងតាក់ទងគឺតាក់ទងទៅនឹងទំនាក់ទំនងពាណិជ្ជកម្មនិងការការពារកិច្ចការពារកម្មសិទ្ធិបញ្ញារវាងកម្ពុជានិងសហរដ្ឋអាមេរិកទី5គឺយើងបានចុះអនុសារណៈជាមួយនឹងកិច្ចសហប្រតិបត្តិការកម្មសិទ្ធិបញ្ញារវាងកម្ពុជានិងថៃនៅឆ្នាំ1997ទី6គឺកិច្ចព្រមព្រៀងអាស៊ានក្របខ័ណ្ឌអាស៊ានតាក់ទងទៅនឹងកិច្ចសហប្រតិបត្តិការកម្មសិទ្ធិបញ្ញានៅឆ្នាំ1999គឺនៅពេលដែលយើងបានចូលជាសមាជិកអាស៊ានទី6យើងក៏បានចូលជាកិច្ចព្រមព្រៀងគេហៅថា TIFA ទី7គឺ protocol តាក់ទងទៅនឹងកិច្ចព្រមព្រៀង Madrid នៅឆ្នាំ2015ទី8គឺអនុសារណៈនៃការកិច្ចសហប្រតិបត្តិការតាក់ទងទៅនឹងកិច្ចការពារម៉ាកនិង GI នៅឆ្នាំ2016ទី9គឺ PCT Patent Cooperation Treaty ឆ្នាំ2016ទី10តាក់ទងទៅនឹង Hague Agreement នៅឆ្នាំ2017ទី11តាក់ទងទៅនឹង Joint Statement of intent on cooperation នៃការសម្របសម្រួលការផ្ដល់បតង់រវាងកម្ពុជានិងរវាង MISTI និង JPO ទី13គឺអនុសារណៈនៃកិច្ចសហប្រតិបត្តិការរវាង MISTI និង IP Office របស់សង្ហបុរីតាក់ទងទៅនឹង Industry Design ទី14តាក់ទងទៅនឹងកិច្ចព្រមព្រៀងដែលបង្កើតអាស៊ានអូស្ត្រាលី New Zealand Free Trade Area and SWATA ទី15គឺ Regional Comprehensive Economic Partnership.
Okay, so in this point, because of time constraint, I would like to share with you all with the membership of international agreement. Okay, so the slide will be provided to the participant. Okay, so we have international. We have a membership. We are a membership of the different international agreement, intellectual property, WIPO into in 1995 in Paris Convention for Protection of Industrial Property, 1998, and we have another agreement on TRIP 2004 and so on and so forth. But because of the time constraints, so relevant to our members and international participants can be say your own cell then. And right now, let me move to our key challenges.បញ្ហាប្រឈមមួយទៀតបងឲ្យចប់ហ្មង
អូខេអញ្ចឹងដើម្បីកុំឲ្យពេលវេលាជិតអស់ហើយខ្ញុំសូមបញ្ចប់ចំណុច key challenge គឺពាក់ព័ន្ធទៅនឹងទី1យើងមានអត់ទាន់មានទេប្រព័ន្ធគេហៅថា IP recognition ទី2យើងមានគេហៅ IP public awareness ហ្នឹងគឺនៅមិនទាន់ជ្រួតជ្រាបទៅដល់សាធារណជនប្រមាណទេទី3 IP infrastructure capacity building នៃ enforcement official ហ្នឹងគឺ cooperation with the right holder relevant authority ចំណុចមួយទៀតនេះគឺយើងនៅមានខ្វះគេហៅថាខ្វះចន្លោះពាក់ព័ន្ធទៅនឹងច្បាប់ខ្លះនិងបទបញ្ញត្តិខ្លះបាទនេះគឺជាគេហៅថាបញ្ហាប្រឈមសំខាន់ៗ
So even our IP in Cambodia has been grow, but we might have some challenges as below, such as no recordation system of IP public awareness is limited, and IP in structure as well, and also capacity building of our enforcement official, and also coordinate with the other right holder relevant authority, and some law and its regulation. So these are our challenges.
ចំណុចបញ្ចប់គឺតាក់ទងទៅនឹង future plan របស់យើងខ្ញុំទី1លើកកម្ពស់ជំរុញទៅនឹងការផ្សព្វផ្សាយចំណេះដឹងផ្នែកកម្មសិទ្ធិបញ្ញារវាងមន្ត្រីរដ្ឋាភិបាលតំណាងមកពីផ្នែកឯកជនសាកលវិទ្យាល័យហើយនិងសាធារណជនទី2គឺជំរុញការសេចក្តីព្រាងនិងរៀបចំច្បាប់កម្មសិទ្ធិបញ្ញាបន្ថែមទៀតចំណុចមួយទៀតគឺខិតខំប្រឹងប្រែងគឺធ្វើយ៉ាងណាឲ្យមានគេហៅកាន់តែមានភាពងាយស្រួលតាក់ទងទៅនឹងនីតិវិធីនៃការចុះបញ្ជីកម្មសិទ្ធិបញ្ញាចំណុចមួយទៀតគឺជំរុញរៀបចំឯកសារពាក់ព័ន្ធកម្មសិទ្ធិបញ្ញាជាភាសាខ្មែរដើម្បីងាយស្រួលឲ្យអ្នកស្រាវជ្រាវនិងអ្នកអនុវត្ត
So this is our last point talking about future plan. So we are going to enhance dissemination of IP knowledge among the government official representative of the private sector, university and public awareness and other stakeholders. And also our plan urge and draft prepare some of IP law and its regulation, and also shall endeavor and to make easier IP procedure, and also push to prepare and translation in IP in our language, and also to continue considering Cambodia accession to some more IP international agreement, and to continue to making cooperation with enforcement body and relevant party to prevent IP infringement, and also Saul in vendor to prepare amendment of the existing IP law in consistent with the international agreement regarding to the IP, which is Cambodian as a member. So this is our presentation, and thank you for your attention, and thank you very much organizer for giving me a chance. My presentation seemed a little bit long a little bit because of if it is not too brief with me, it seems that it is not much more information for me. So I thank you much again for your attention. Thank you.
Thank you, Mr. Tao, for your very comprehensive account of the IP regime of Cambodia. Am I to understand that you are willing to share your slides with the participants of this webinar? Can we send your slides to the participants who registered for this webinar?
Yes.
Because it's very rich in content.
Yeah, so he is okay to share this material to the participant as we understand our presentation. It seemed to critical and too long a bit and technical term to understand. So the slide would be great to send to the participant, and if they have a particular question relevant to the trademark issue, trademark law. So please keep us in touch by email or telegram. So we appreciate.
Thank you very much, Mr. Tao, and thank you, Mr. Lash, for interpretation.
Thank
I
you.
am sorry on this aspect for international speaker. I am sorry for translation because of I am not the expert in translation. This is my first time, and thanks for your understanding.
Thank you very much. Yeah. Okay. Then we will go to the next session where we have 4 speakers, respectively from India, Indonesia, New Zealand, and Vietnam, talking to us about developments of trademark laws in their country. So as time is running out, we will start quickly with Mr. Vaibhav Vutts of Vutts and Associates of India. Can Mr. Vutts please share your screen?
Thank you, Rebecca. Rebecca, I think I can still see the previous slide if that can be taken off.
Yes, Mr. Lash, can you unshare your screen first? Mr. Lash?
Thank you, Rebecca.
Yeah.
Hi, everyone. Can you see the slides?
Yes, we can.
Brilliant. Thank you, Rebecca. Thank you, everybody, for listening. Since time is short, I'm going to quickly get into the developments of trademarks in India. There will be 3 topics that will be covered today. The first topic is legislative developments. The second would be certain administrative side of it and certain case laws that have come over a period of time, especially in the last 1 year. This particular presentation is mostly focused on the developments that have taken place in the last 1 to 1.5 years. Otherwise, it will become very big, and I'm focusing only on the highlights of the last 1.5 years. Probably one of the most significant legislative change that has taken place has been the abolition of Intellectual Property Appellate Board by a Tribunals Reforms Ordinance in 2021. For those who do not know what IPAB is, IPAB was a forum which was created in 2003, where all the appeals and cancellations were filed from the IP office. This had its own issues. Subsequently, with the passage of Tribunal Reforms Act in 2021, by August 14, 2021, it was IPAB was completely abolished. IPAB had 2 members, and there was always a problem that the appointments were not taking place on time. For the period of close to 20 years, IPAB had hardly worked for about 8 or 9 years. And even then, there was a lot of issues regarding independence, appointment, quality, and plus a lot of lack of resources. So the government, in its push to sort of reduce the tribunalization of justice, moved everything back to the high courts and the commercial courts in India. This is something which is very significant because it directly impacts the right owners. And a lot of applications and a lot of cases have been pending in IPAB. So close to about 3,000 odd cases have been transferred to the Delhi High Court itself in the last 1 odd year. So one of the first courts in India which took the lead was the Delhi High Court. And with the help of the stakeholders and lawyers, including us, IPB rules were framed very quickly. And it took about 8 to 10 months to frame the rules, but they have come out with the rules on 24th February 2022. There is Delhi High Court Intellectual Property Division rules, and for patents, a completely separate set of rules for governing the rules regarding patent suits in the Delhi High Court. IP division, in a nutshell, essentially refers to a single judge who's presiding over IPR subject matters. As of right now, there are 3 judges who have been exclusively created are sitting to take care of IPR related subject matters. So it's a good development. Based upon the rules that have been framed in Delhi, other states, other 4 jurisdictions, namely Ahmedabad, Mumbai, Kolkata, and Chennai, have also taken more or less the same set of rules and have enacted them, are either using them directly or are in the process of putting them in place in their respective jurisdictions. So which basically means that to a right holder, there would be a large level of consistency across the board in terms of rules and regulations. As many people might have known that filing appeals in India could sometimes be quite cumbersome with the amount of paperwork. And so the idea is IPD has taken into account to reduce these paperwork. The subject matters that are being covered under IPR, the IP division are relating to patents, copyrights, trademarks, the classical IPs, including any other IP that may come along the way. Likewise, it would deal with the matters of passing off, unfair competition, disparagements, comparative advertisements, be it confidential information, privacy rights, publicity rights. It could be issues relating to data exclusivity, domain names, and largely today a lot of market is on intermediaries. A lot of business is happening over the internet. As a consequence, even the intermediary and e-commerce related issues, which have a direct or even an indirect connection with IPR, IP subject matter, the high courts are taking those on. So in many ways, this is actually a good development because we are going before the same forum, which is going to decide an infringement and a passing off or any other right, as well as if there is a cancellation action filed against the same trademark. So it makes the life for a right holder good, makes it a little more consistent, rather not more, very consistent. The subject matters that would be covered would be original proceedings, any appeals that are coming from the IP office, all cancellation and revocation petitions, any suits where IPR subject matter is involved. It being a high court, for those in India, the high courts have something called an extraordinary jurisdiction under writs. So they are for the enforcement of fundamental rights. But the law has developed, and for those who from the common law country would know about laws regarding where the courts can take cognizance and quash orders or direct the government to do certain things. So all those writs and appeals and civil revisions, everything comes under the IP division, which again helps in keeping a check on IP office. All pending proceedings before IPAB obviously have been transferred to the Delhi High Court. After the abolition of IPAB, there was a parliamentary standing committee report on IP regime. This provided a slew and a long list of recommendations, largely to do with patents and mathematical methods and plants, etc. Since we are on the trademark aspect, the relevant part over there was a suggestion to revive IPAB, which in my personal opinion is counterintuitive. After abolishing a tribunal, to reset up a tribunal would actually be counterintuitive and not help anybody. But I don't think so. This is gone forward, but it is one of the many recommendations. This particular report is quite pro-industry, and but there was a very little stakeholder interaction. That was on the part of the legal the legislative developments. On the administrative developments, this is mostly statistics. What is happening is for the last couple of years, because of the pandemic, the annual report has not yet been released by the Indian Patent Office. So therefore, the data that we have is that of 2019 and 2018. But what is important over here is there were about close to 278,000 applications that have been filed. Close to 264,000 applications are registered. From what we estimate, there has been at least an increase of 10 to 20% in the filings, and the number of grants has gone up much more than that. The other administrative development that has taken place is that earlier, when I started practice, I was doing examination reports of 13 years old. The life of a trademark was 10 years, and I was doing an examination report which after the life of a trademark. Now that has come down to close to 6 months. In fact, they're trying to bring down this period to even 1 month now. There has been an average pendency of show cause hearing has reduced, and it has come down to a couple of years. In fact, this is a conservative figure. It's come down even more than that. Certain other developments which are good is because of the pandemic, all the hearings under the trademark, before the trademark registry are through video conferencing. So this has really helped in cutting down the cost and making things faster for agents as well as brand owners. Smooth cases are getting registered within 5 to 6 months. There is also a chatter that there is a possibility that there is a mandatory period of advertisement of a trademark is 4 months in India. That might be reduced to 2 months. So that might even result in trademarks being granted in 3 to 4 months. So which is, I guess, a good development. Amendment. There have been notification and court orders that require the trademark registry to pass orders which are reasoned. Now, on the judicial developments, there have been quite a few, and I've just culled out a few of them. Probably the most significant one was during the pandemic, the Supreme Court on March 25th, by even before the lockdown in the country was announced, Supreme Court had had seized the situation, and through a particular suo motu writ petition had extended each and every deadline, be it for general law or for special law, and that included trademark laws also. And through the period of pandemic, the Supreme Court ensured that any kind of ambiguity or confusion is removed. As a consequence, during this period of 2 years, no right holder has ended up losing any of their rights. And if anybody has lost any rights, those rights have been reinstated by a simple writ before the courts. So this was actually a very significant step taken by the Supreme Court. The other development vis-a-vis trademark side was that this particular case of Pavandeep versus Registrar of Trademarks was in March 2022, where an applicant was waiting for his turn to come, but he was kept to wait in the waiting room, and eventually the application was refused. And the reasoning given by the registrar was that he did not appear. So obviously this was false, and the court came down very heavily on the registry and stated that the orders that are passed by the registrar are precious rights and they relate to trademarks of individuals and businesses. A refusal of trademarks without even affording a hearing would be contrary to the fundamental tenets of natural justice. In India, we follow natural justice, so that would mean that every person has a right to be heard. So, and right to be heard cannot be mechanical. It has to be reasoned why you have why a particular person's right should be or should not be allowed or curtailed. The court also noticed that the order captures that the hearing took place, whereas in fact the counsel was waiting in the waiting room. So this was an illegality which had taken place, and being a quasi-judicial body, the registry should not have done this. Likewise, the issue was the court also observed and after this passed certain orders. They said that the VC, the video conferencing facility used by the trademark registry, does not allow many people to join. In fact, it only allows 3 people to join. And this is grossly insufficient and outdated mode of hearing. For example, the High Court and the Supreme Court, anybody in the country can log in and see what is happening. But in the trademark registry, nobody knows what's happening. So the hearings are supposed to be open and not only should be fair, but also appear to be fair. So there were some directions and proposals which have been provided to the Controller General, wherein he's been asked to devise a proper mechanism for holding hearings by including the following features. Things like cause lists on a daily basis. Things utilizing platforms like WebEx, etc., which are open and which allows many more individuals to join and to see how the proceedings are being conducted. Many a time, the registrar doesn't even show his face or half his face. So all of those things have to be curtailed. Matters can be called out serial-wise. Removal of templates so that issues like the hearing took place before me do not arise. and a little bit of space in the order so that the controllers, the registrars can pass proper orders if they have any comments to make on it. Likewise, in India, one of the critical thing which has been realized is oppositions. There are close to 200,000 opposition proceedings that are pending in the trademark office. And in a particular case, the court again took cognizance as close as in March 2022 to create a mechanism to dispose of these 200,000 oppositions. These oppositions were, this was one of the issues which was there. Among this particular case dealt actually with a scenario where an opposition was not being taken on record by the registrar, and eventually the registry, the officials were imposed with a fine of $1,500 each, which was deposited with the Delhi High Court Bar Association Pandemic Relief Fund. So for not disclosing to the court and their own counsel that despite of the Supreme Court orders of extension of time, these controllers and these registrars had allowed trademarks to be registered despite of oppositions being filed against them. So this led to a lot of changes. Moving on to certain interesting cases. Injunctions in trademark is pretty much common. Everybody knows about them. Why this case strikes out is the fact that this involved pharmaceutical, in fact, it involved medicines to be used in relation to COVID. And the defendant said that, yes, we have infringed. The court came to the conclusion also that you have infringed. But the defendant stated that let us allow to at least clear the stock because these are medicinal supply, and based upon that, suspend the injunction. However, the court said that the argument of urgency and public interest was held to have no bearing on the question of trademark infringement, and that such a ground could not be a reason to violate the plaintiff's right. This opens the whole Pandora's box and it is open for interpretation. But in this case, the court stuck to the principles of interim injunction and did not allow the concept of public interest becoming an issue, because that is a very common ground which is taken by many defendants, that it is medicine, public interest is involved. But the other side of public interest is an infringing product would not match the quality also. So a public interest cannot become only one-sided. It has to be balanced with a private right. This was an interesting case. This particular case was that the plaintiffs said that Google's ad platform was actually allowing third parties to use the trademarks of the plaintiff as keywords or meta tags. Google's argument was that these trademarks are invisible. They are not even used in a trademark sense. Consequently, as they are not used in a trademark sense, they cannot be considered trademarks under the trademark law, and consequently there can be no infringement. Court held otherwise. They said no, the use of Google ad platform does qualify as advertising. Within section 29, there is a particular provision where even advertisement for the purposes of infringement would be considered use in the course of the trade. And by quoting the section, the court actually came down on Google, saying that Google's keyword policy on third parties' trademark is actually restricted. Further, the court went on to take a step further and asked Google to investigate complaints made by the plaintiff, alleging that its use of keywords and overall effect of advertisement to check if it results in infringement or passing off. The short point over here is third parties can buy my trademark as a keyword and then slot their advertisements against this keyword. So what is happening is, if somebody comes today and wants to look for Vutts and Associates, my competitor buys my brand. All he has to do is, every time somebody types Vutts and Associates, what is going to come up is the competitor's law firm, and that law firm, and as a consequence, it catches the eyeball of a consumer, and that consumer is making benefit by using a keyword which was actually looking for me and not for him. So that is what the logic and the premise is. I thought this was quite interesting because it dealt with invisible trademarks. This is my last slide. this has got to do with the interesting case of Tata versus Hakuna Matata. And it was quite fascinating because Tata is a declared well-known trademark in India and in many parts of the world. I'm sure many people in this conference also know about the brand, and Tata has been extremely successful in stopping people from using the brand Tata. But in this particular case, Tata was trying to enforce a right against the defendant who were not even based in India. So consequently, the court said that Indian laws are territorial in nature and there is no long arm statute which exists under the Civil Procedure Code or be it under the trademark law. Consequently, they said that Tata Sons does not have sufficient grounds to maintain a suit in India. If they want to file a suit, they are more than welcome and go and file it in in USA. The aspect of internet jurisdiction also came over here, where as a general rule in internet on a website, if a particular website is interactive, it is considered to be sufficient to create a jurisdiction. So, however, the court said that even the interaction has to be a little bit, it cannot be passive, it has to be active, and the interaction has to be a little bit more than just a few people. It cannot just be 5 people or 10 people. In a country of billion people, showing 50 people saw the website is not sufficient. The effect, it was not sufficiently shown that the effect of use of Hakuna Matata cryptocurrency to be purchased in US and UK is going to be felt in India. And the long arm statute, the concept of long arm statute was reiterated and it was brought into the aspect of trademark laws as well. I'm going to close my presentation over here. There are tons of things which have happened, but I've tried to keep it as brief as possible and just picked up certain interesting and important cases. I'll be available over the chat and after the presentation. Any questions, please feel free to ask. And thank you so much for listening and your patience. Thank you so much.
Thank you, Vaibhav. The next speaker is Ananda Ramadhan Maulana of Maulana and Partners Law Firm of Indonesia.
Thank you, Rebecca. I will share my screen. Is it appearing?
Yes, it is.
Okay, thank you. Hello, everyone. So I'm gonna talk about tips on handling trademark lawsuit in Indonesia because I believe there are so many foreign party, either company or individual from foreign nationality having a trademark lawsuit in Indonesia. So I believe these things will helpful for you all. So first, the preparation. If you seek trademark lawsuit in Indonesia, you need to provide your legal counsel in Indonesia a power of attorney, in which notarized and legalized at Indonesian Consulate General or Embassy. And then you have also provide the Indonesian legal counsel original company registry and or the original company article of association. It is important because the panel of judges in Indonesia will check whether the one who signed the POA, the power of attorney, is someone capable or have the ability to represent the foreign company in Indonesia and before the court. Okay, so where the foreign party filed the trademark lawsuit in Indonesia, it's based on the trademark law in Indonesia. You have to file through Jakarta Commercial Court at Jakarta Pusat District Court. Either the plaintiff or defendant is a foreign legal entity, then you have to file the trademark lawsuit through Jakarta Commercial Court. Even though there are 5 commercial courts in Indonesia, Jakarta, Semarang, Surabaya, Medan, and Makassar, only on these 5 big cities, because many businesses happen in these 5 big cities. This is the map of commercial court in Indonesia. Is from the western part of Indonesia. There's Medan commercial court, and the most eastern part of Indonesia, there's Makassar commercial court. But since many of you perhaps will seek trademark lawsuit in Indonesia, then you have to file through Jakarta commercial court. So I believe in many countries you have this kind of trademark lawsuit, the non-use cancellation lawsuit. In Indonesia, we have the 3 consecutive years non-use cancellation lawsuits, the cancellation lawsuit, and the compensation lawsuit. And for the non-use cancellation lawsuit, at least you need to provide these 3 evidences. You have to provide the survey that the trademark, the defendant's trademark, is not been used for 3 consecutive years, and it is better if you request from the legitimate surveyor company. And then you have to provide the original trademark certificate, or at least the trademark filing receipt if your client trademark has not been registered in Indonesia. And one of the most important thing, then legal standing. Why you have to file the non-use cancellation lawsuits against the registered trademark? But based on my experience, I will not recommend you to file the non-use cancellation lawsuit, because it is very difficult things in Indonesia, because Indonesia is so wide, so big. There are so many people who have small or medium, even micro businesses. So sometimes the person who run their business in deep area of Indonesia don't understand about the trademark registration. So they will just use their own trademark to run their business without registering to the DGIP office. But then it will be difficult if they are sued by someone from a foreign company or from a foreign party, because you have to prove that the trademark has not been used, while in fact the trademark is used by that person. Next, the cancellation lawsuits. At least there are 5 main evidences you have to provide. And I really recommend you, if you seek for a cancellation lawsuit in Indonesia, to claim that the trademark is a well-known trademark, even if the trademark only registered in 3 or 4 countries, then it is fine. You can just claim it as a well-known trademark, because the panel of judges in Indonesia will easier to understand that you have a strong trademark rights if you claim the trademark, your trademark as a plaintiff is a well-known trademark. And then you have to provide the original trademark certificate from the other countries, and proof of wide investment in many countries, including in Indonesia if there's any, and also proof of massive publication, not only in Indonesia or your origin country, but in many other countries. It is important. Next, the compensation lawsuit. It is also one of the most trademark lawsuit happen in Indonesia. First, you have to provide the evidence, proof of infringing product. You have to show to the panel of judges that there is the product that infringing your trademark, and you have to calculate the actual damage you receive from the infringement by the defendant. By providing the exact calculation of the damages, the panel of judges will see that the defendant actually causing damage to you as a plaintiff. Okay, so this is one of the case example. I believe is one of a good case, because the Farifas from Japan file a trademark cancellation lawsuit against Farifas, in which registered by Indonesian party. And Farifas Japan has won in 3 stages of court. First, they won at the commercial court, and then during the cassation at the Supreme Court, they won again. And the last time the defendant filed a judicial review, then the Supreme Court also reject their judicial review petition. So at the moment, Farifas has finally won these 3 stages of court. Using this example, the evidence they provide, the Farifas Japan provide, first, the trademark registration in many countries. So they provide the original trademark registration in many countries. And then they also provide the original brochure and publication from many countries. And luckily enough, they also have the local distributor in Indonesia, which already provide the statement. So through this, at least 3 evidences, the panel of judges understand that Farifas is a well-known trademark, particularly for fishing products. So during the hearing, likely enough, the judges also have a fishing hobby, so they have heard about this trademark, about the Farifas trademark. So it's also giving the stronger argumentation for us that Farifas is a well-known trademark. Also, during this internet era, there are so many people, local people in this case, providing a review about the Farifas product. So they provide the evidences from YouTube, from Instagram, that people also really know about this Farifas trademark because they have fishing as a hobby. So it is the people's review in social media is also very helpful for Farifas winning the case in Indonesia. Next, this is the trademark litigation process in Indonesia. Basically, after you file the lawsuit through commercial court, the court will summon both parties, the plaintiff, the defendant, and co-defendant, if any. And the first hearing will be parties legality check. So that is why it is important for the plaintiff, if it's from a foreign party, to provide the original identity. If it's a legal entity, then you have to provide the original certificate of registry, company registry, or the article of association, because during this first hearing, the panel of judges will examine whether the legal counsel having its power of attorney from a person in the company who really have rights to represent the company before the court. And this whole trademark litigation process only takes about 90 days in Indonesia. And after that, the panel of judges have to issue its decision. I think that's all from me. Thank you, everyone. And if you have any inquiry, you can just send it to my email or through my WhatsApp. Okay, thank you.
Couldn't hear you, Rebecca.
Oh, sorry. Yeah, I muted myself. Yes, the next speaker is Tom Robertson of New Zealand. Tom, please.
Hello, everybody. Most welcome and very pleased to be taking part today. Today, I'm just going to be talking about sort of recent changes and proposed changes to New Zealand trademark law. In 2020, there was some changes were made, and I'll just talk through those first, and then I'll follow up with some proposed changes that hopefully will be coming into into law within the next few years or so. Now, in the grace periods for late renewal used to be 12 months, and in 2020 that was reduced to 6 months after the expiry date of renewal. And this sort of lines us up with Australia and other major jurisdictions around the world. Another thing that was done was the revocation provisions were clarified so that it is clear that there is no discretion that the IPONs or the courts could apply when the grounds for revocation have been made out. Previously, that discretion was there. So, for example, if you had a revocation proceeding and you managed to show that the trademark hadn't been used, there was still a discretion there that the commissioner or the courts could still allow that registration that you're trying to revoke to stay on the register. Now, that discretion has actually no longer able to be applied. If the registered trademark has actually not been used and there's no special circumstances to sort of specify why it should stay on the register, then that trademark will be removed forthwith. A third party can seek to revoke a trademark during the renewal grace period, during that 6 months grace period. Previously, you couldn't do that. You could only revoke a trademark for non-use if it was still a registered trademark. If it had expired, even though it could be restored, you could not actually revoke it, but now you can. Also, you can actually assign a trademark now if it has expired, but is still within that 6 month grace period to be renewed. You can now assign it where previously you could not do that. In relation to certification marks, you cannot get a certification mark now where the goods and services are the same as a standard trademark that you already have registered. Okay, so you can only have one or the other for the same goods or services. Also, security of costs in relation to a hearing matter may be required where the party is based overseas, or if there is a reason to believe that the party will not be able to meet costs. So those are the changes that came into force sometime in 2020. Now to move on to proposed law changes. These were first sort of brought forward back in 2019, and they still actually are going through the parliamentary process. And it looks like at this stage, it might be late 2023 or sometime 2024 before these proposed changes will be able to be come into force. Series applications can now only be limited to 4 trademarks within the same series, whereas previously, or what you can do at the moment, you could have multiple numbers. You could have 5, 10, or 20. But once this change comes in, you can only have up to 4 series trademarks. There's going to be a specific provision added to the Act where prior continuous use of a trademark can be used as an exception to overcome a prior registration objection. At present, there's this bit of doubt as to whether prior use constitutes a special circumstance in which that can be an exception. But once this provision is changed or added to section, what we call section 26(2) of our Act, then you will be able to rely on prior use as an exception as to why your trademark should be registered, even though you've had a trademark cited against you. In respect to memorandums, they can only, once this new provision comes in, they will be only able to be to matters that affect the nature and scope of the rights conferred to that registration. As well, to ensure consistency between national applications and New Zealand designations from an international registration, the Trademark Act is going to be amended so that to allow partial refusals for standard applications. At the moment, you can have partial refusals in relation to a New Zealand designation, but you cannot have that in relation to a standard application. So they're going to try and make it so that it's a fair playing field, because why should you have one type of trademark that's you're allowed to have a partial refusal, but then another trademark application, you cannot have that ability. So that's going to be clarified in the new provisions. Another, in relation to international New Zealand designations of international applications, it's going to be added to clarify, to make it that unclear specifications aren't allowable. So that it gives the IPONS examiners the ability to insist that the specifications are clear for international New Zealand designations from international applications. Another change is going to remove the grieved person requirements for revocation proceedings. At the moment, you actually have to be an aggrieved person in order to take a revocation proceeding. That is, that you either the registered, you're in the same sort of trade maybe as the registered trademark that you're thinking of revoking, or you may have a trademark application that's been blocked by a registration that hasn't been used. So you'd fall into the aggrieved person status. That's going to be removed, so anybody can actually apply to remove a trademark from the register without actually having to prove that they're in the same sort of line of business or other circumstances. And lastly, the New Zealand Act is going to be clarified such that contrary to law provisions will not include the New Zealand Trademarks Act. At the moment, it could be read that you could actually include that as a contrary to law provision. It seems a bit senseless that why would that be the case? Now that's going to be clarified so that you cannot sort of rely on the trademark law. It has to be some other law, other legislation, which the trademark that's been applied for is going to be contrary to. So that's my summary of what's likely, what has happened and what is likely to happen in relation to New Zealand law going forward. And so if you have any questions, I will make my notes available to Rebecca to allow participants to have access to that. So I will do that. So thank you and good luck.
Thank you, Tom. The last international speaker is Ms. Nguyen T. Tu Ha of Vision and Associates of Vietnam.
Thank you, Rebecca. Let me share my presentation.
And while Ms. Nguyen is sharing her presentation, I would like to mention that for participants who have typed questions into the Q&A box, actually, in the interest of time, we will not be having live answers. But on the other hand, if you click into the answer section of the Q&A, you will see that your questions have already been answered in writing. So take a moment to read that, to read the answers later on. Now, Ms. Nguyen, please go ahead.
Thank you. Good morning, everyone. My name is Ha. I come from Vision Associates Vietnam. And today I will make a presentation, a very short presentation on the changes regarding trademarks under the amended IP law of Vietnam. As you may know, in June this year, the National Assembly of Vietnam approved the amended IP law. This is the third time this law has been amended since its issuance in 2005. The amendment this time is quite in wide scope and comprehensive, affecting 102 provisions under the current law. That means nearly 50% of the provisions under the current law are now revised or amended. More than 10 articles are added, several articles are removed. Related articles in other laws, such as the law on custom or the law on science and technology, are changed accordingly. And the amended IP law shall take effect as from the 1st January next year, 2023. Following other notable changes regarding trademarks. The first one, we now protect sound marks. This is a commitment of Vietnam under the CPTPP trade deal. Also, the examination of sound marks shall be subject to specific regulations applicable to such type marks. Some of those you can see in the screen. I believe this is a big step forward of Vietnam in enlarging the scope of IP protection in our country. Just a small note, the protection of sound marks in Vietnam already took effect since January this year. That means at present, trademark holders can file applications for their sound marks in Vietnam. And if they do so, I believe their applications may be one of the first applications for sound mark in Vietnam. And the next one, we now have clearer criteria for recognizing well-known marks in Vietnam. Accordingly, the requirement for consumer awareness of well-known marks is now limited to relevant sector of the public, not the general public or the public at large. Further, the law is now more specific on criteria for assessing registrability of 3D marks. As you can see in the screen, I just mentioned the three circumstances open falling in one of them. The 3D marks shall be refused. These criteria may be very common or very popular in other countries under the laws or in practice, but this is the first time they have been stipulated in the IP law of Vietnam, and they can facilitate much the examination of 3D marks in our country. Then the law now reduces the isolation period from 5 years to 3 years. By mentioning the term isolation period, I mean the period of time after the expiry of trademarks in which the expired trademarks can be used as citations against similar letter 5 marks. Under the current law, it is 5 years, and under the amended IP law, it is just 3 years. And to me, this is a very welcoming change. Next, the law now allows the stay of trademark the law now allows stay of trademark prosecution awaiting outcomes of cancellation or invalidation proceedings against citations. This has been a common practice in Vietnam for a long time, but it is now reflected into the law, and such change is also welcoming. The next one, we now have more grounds for refusals, for cancellation or invalidation of trademarks. And among these grounds, it is noted that the ground of bad faith filing is now officially provided as the ground for opposition, for refusal or invalidation of trademarks. And also the use of trademarks that causes confusion to consumers as to nature, quality, or geographical origin of the goods and services can be used as the ground for cancellation of trademarks. And this is a commitment of Vietnam under the EU-Vietnam Free Trade Agreement, and it is now reflected into the law. Also, the law now differentiates between opposition and observation proceedings. This will facilitate much the examination of IP application, especially trademark application in Vietnam. For trademark opposition, we now have fixed opposition period of 5 months after the publication date of the application in the IP Gazette. And the trademark opposition will be conducted in accordance with a specific procedure to be stipulated by the government. But for trademark observation, such observation can be filed at any time during the trademark examination, but it is just considered as a reference for the IP Vietnam during their examination. Yes, my presentation is very short, and it is just some notable changes regarding trademarks under the IP law, and it does not cover all the changes under the law. And so should you have any queries or questions concerning this matter, I'm happy to answer. Thank you.
Thank you, Ha. Since time is running out, we will go straight to the next session which is about dealing with office action in trademark applications in Cambodia. And our speaker is Mr. Vichet Ny, who is also the president of APAA Cambodia Group. Mr. Ny, please.
Yes, good morning, Rebecca, and all speaker participants. My great pleasure to provide you very brief. I will go to directly to the presentation, very brief on the how to deal with the office action of the refusal. So I will go roughly and very quick to the 5 points on the overview of the trademark protection under Cambodian jurisdiction, requirement for the mark registration, the ground for refusal, and how to overcome the refusal, and right of the applicant to appeal the refusal. It still happen. So a quick overview on the legal framework. We have applied the trademark laws in 2002, and we also have the procedure on the implementation of the trademark law in 2006. And also Cambodian is the matrix. I will not go to the international application. I will cover only on the national side because even though the mark applied to matrix protocol is also applied with the requirement for the trademark registration procedure in Cambodia as well. So there are 2 layers recently that for obtaining the protection of the trademark under Cambodian jurisdiction. You can go through the trademark protection by the national trademark registration system, where the mark will be protected once it is registered. If it is not registered in Cambodia, it is not protected under Cambodian territory. So this is the principle of the territorial protection of the trademark, and not different from the other countries. Once the mark is successfully registered in Cambodia, it will be protected for 10 years, and the applicant have the right to unlimited renewal of the mark every 10 years, as long as you wish to use it. And the second layer of the protection is the protection of the trademark or registration of the trademark through the international system, where we use a matrix system. So, what are the requirements of the trademark registration in Cambodia? It's under the current applied law, the mark, only the visible sign or visible marks are accepted for registered in Cambodia. So the law provides the notion of the mark clearly, that the mark means any visible sign capable of distinguishing good or service of one enterprise to another. So we seem not accept by parallel interpretation. Cambodian seems not accept the registration of the non-traditional mark like sound, smell, taste. However, we can try to file, but I didn't see any successful registered yet for the non-traditional mark. So basically, only the visible sign would be letter, number, color, picture, logo, any drawing or combination thereof could be accepted for registration in Cambodia only. So there are some requirements not different from the other country. The marks must be distinctive. If it is not distinctive, it is not accepted for registration. That is the general principle for the mark registration. So the characteristic of distinctiveness is detailed in Article 4 of the law, where the mark could not be accepted for registered if it is descriptive or it cannot fulfill the function of distinguishing of good or service from one enterprise to another. It confuses the public, or it's contrary to the public order or morality or custom of the country. It confuses the public in the trade cycle or geography indication. So there are some criteria that detail in the Article 4. You can see it and go one by one. If a mark falls into either one of the limited prohibited condition, it is not accepted for the registration. So this Article 4 is the main ground for the refusal. So the refusal could be divided into two classes. It should be absolute or relative ground. So from the trademark examiner, Article 4 is mainly used to refuse to the application of the mark. So it could be absolute if it relates to the quality of the mark or ability of to the function as the mark mentioned in Article 2, as mentioned previously in the trademark law. So if the mark is generic, descriptive, or contrary to public order, morality of the custom, or mislead the public of in trade cycle, or the mark contained any symbol of the state of Cambodian or other state or the other international organization, so the marks will be refused from the registration. The second class of kinds of refusal is about the relative ground for refusal, where it relates to the conflict with either rights. That means if the mark applied in Cambodian is considered as similar to or identical with the existing one in Cambodia, or a well-known mark or well-known trade name in Cambodia, it cannot be accepted for registration under Cambodian law as well. I try to provide you some example under our trademark perspective. Please note that the concept of the interpretation of Article 4 mainly depending on the knowledge of the examiner. So in practice, we try to convince or try to overcome each of the refusal by each ground raised by the examiner. Now, I give you some example to illustrate this ground of refusal. Example, the mark Mr. Clean. It's filed by a private company in Cambodia in 2019. It was refused by the examiner for lack of distinctiveness. The mark is descriptive, very descriptive. So Mr. and Clean, you can find this word in the dictionary. Clean, right? Mr. is a title used for everyone. So 4A is the ground for lack of distinctiveness. So the mark is rejected from the registration in 2019. The second example, the mark Mozaka. I don't know Japanese. Our president left, so I cannot translate. So Mozaka, to my understanding, is the name of a food in Japan, and it's used for BBQ and soup, filed by Cambodian individual in 2020. So this is a generic term, and also the logo, the picture that they use is just it's so the food or the sign of the food. So the examiner refused the application in class 43 for operation business restaurant for lack of distinctiveness as well, but on the ground that it is a generic word, so it is not deemed as distinctive signs for these kinds of restaurant service. The third example, Japan Home Center word. It's a word mark filed by a Cambodian company in 2018. The examiner also used the ground for refusal as the mark contained the name of the country, or that is not allowed to use in Cambodian exclusively for a company. Otherwise, the other Japanese company cannot use the word Japan in Cambodia. So it is related to the mark that contained the symbol or the name of the country, where the examiner has the ground to refuse it. The fourth example, Dumex, its sound is similar. So Dumex, the first one, Dumex in word is filed by the Cambodian individual as well for operation business in Cambodia in class 12 in 2021. So this mark is confusingly similar to a well-known mark, Dumex of Denmark company. So Denmark company, they have the evidence of the well-known marks, not different from other country. We do not have a specific criteria, but as long as you prove the length of use, the scope of business in trade cycle, so that mark is well known in the country or in the other country of the convention where they are member. It can be deemed as a well-known mark. So Cambodian is protecting the well-known mark among the country members of the agreement or convention that we are also members. So in this ground, the examiner reviews based on the similarity of the mark to a well-known mark, which is used in the same classes. So this confused with the existing one. The final example, protect and protected sound is the same as well. The word protect filed by Indonesian company in Cambodia, and it is not accepted for registration as it sound like it is identical to registered mark and in the same class 5, which has already been registered by a USA company, American company in Cambodia, protects. So it sounds the same, and it's the same class of code, so it cannot be used as a mark under Cambodian law, Article 4G. Yeah. So once the mark is filed in Cambodia to the DIP or Trademark Office of Cambodia, there are 2 steps of examination they will take. Formality check and substantial examination. So formality check, I don't go further because it's just a format that you have to comply with a local format that they design for the application. The substantive examination, the examiner will consider to the Article 4 first, and in addition to that, they use the other criteria for comparison or for examination like sound, appearance, or how they use in the trade cycle for a perspective in practice, in commercial practice. So there are various criteria where the examiner has discretion to take for their decision. So in case of the refusal, we still have the right to overcome in the sub-degree of implementation of the trademark law. We have 60 days, the applicant has 60 days to provide the counter ground to overcome the refusal from the examiner. So how to overcome that? I cannot say in the comment then because it's a various. So each item of each legal ground used by the examiner are various, and based on their knowledge, based on their skill, each type of industry. So I just can give you some example how to overcome in real practice. So example number 1, the mark Princess Clinic and P Princess. Both are filed, the P Princess filed in 2014, and the later filing is in 2019. The mark Princess Clinic was rejected. Firstly, by the examiner based on Article 4G, where the trademark is similar, identical to the registered P Princess mark in 2015. So how to overcome this? The mark is successfully registered, Princess Clinic, based on the fair use of the mark. So the fair use, that means the owner does not copy from the previous registered, the existing mark P Princess, nor use later than the P Princess. In history of the use of the Princess Clinic, he has a document to prove that it has been used for more than 10 years already, but not registered. So this is the fair use where he is not copied from the existing mark where already registered later after his use in the trade cycle. Second example to overcome the refusal, Article 4A, for the lack of distinctiveness criteria, it is the mark Sunbite was filed in 2020 and was already accepted in 2021 after challenging the examiner by providing or using the ground of disclaimer system. That means if the word contain the noble word or generic term, somehow at some time you can use the disclaim. That means you disclaim the word son, because son is a generic term where we can be used by everyone, not exclusively used by one person or one company. So the examiner accept the disclaimer system, which is in use in Cambodian system trademark as well, if they found that the word or that sign is not logically belong to only one person, or is a generic term that we can use in the dictionary, etc. So this claim system is key use as well in Cambodian system trademark registration. Another example, but this one is not easy to overcome it, but we have the way to overcome it. But I just said it is not easy one. Belt Road, I think you know the word Belt Road about that, right? It's a big international organization of China, and try to build the one road, I think, one road trade. And there's a company in Cambodia, and they try to use that word to register. So the trademark examiner completely refused it based on the Article 4D, where they use the word confusingly with the name of the international organization. So there is a way to overcome on this ground of refusal is the applicant shall obtain the consent letter or agreement, allow him to file that word or that sign as a mark in business in Cambodia. If they have that consent letter, so the examiner, of course, no more confused, no more refuse on the application. But it's not easy. It's not easy to overcome this one. You need to do a lot of homework to get the letter of consent. For example, the mark Star Plus and the mark New Star. So New Star has already registered in 19, and Star Plus was filed in 2019. So the trademark examiner has refused the mark Star Plus due to the similarity or identical with the existing mark New Star. However, in this case, you can overcome the refusal by changing the logo to make it different, to make it distinctive. That means you use any way to make not confused or not identical to the existing mark. So then this is the only way that you can overcome the Article 4G of the trademark law on the ground that the mark is confusingly similar to the registered mark in our system. I will go a little bit quick on the appeal. So there is no specific law on the procedure of the overcoming refusal. So as long as you want to overcome, you want to provide counter ground against the refusal, you still can do. But normally in practice, you can do only 1 or 2 times only. And then if you are not happy with the decision of the examiner, you can go to the appeal board of the trademark office. Unfortunately, the appeal board exists in the regulation only, but in practice it's not yet successfully established. So the Ministry of Commerce, Mr. Torres, will work a lot on this to establish the appeal board. However, in the law of the trademark law, Article 62 does not block you from filing complaint if you are not happy with the decision of the trademark office. So you still have the right. Article 62 of the trademark law grant the applicant the right to file the complaint to the court if you are not happy with the decision of the trademark office. So you have 3 months to file the complaint against the refusal to the court from the date of the decision, the receipt of the decision of the trademark office. So just highlight for you that there is no special court in Cambodia yet. There is no commercial court yet. The Ministry of Justice is working on that. Hopefully it will successfully created soon. And we do not have IP court, neither administrative court. So the court of the general court will handle this case. So this is just a highlight for the complaint in case the applicant wishes to file the complaint and get a refusal to the court. So just go to the general court of each province. So that's all for my presentation here. So thank you very much. If you have any question, please raise up. Thank you.
Thank you, Mr. Ny. There is a question for you. So can you please take a look at the Q&A session? Now,
Yes,
the final
thank you.
speaker of today is Ms. Chandavya Ing, who will talk to us about what constitutes trademark infringement in Cambodia and how you can conduct enforcement action. So Davia, please share your screen.
Yeah, thank you, Rebecca, for the floor. Let me share my screen. Okay, so welcome to the last topic of today's webinar. It will be about trademark infringement and enforcement actions in Cambodia. For the this discussion, it will be divided into two parts. The first part will be about the discussion on trademark infringement, which will talk about like what are trademark rights, what constitute trademark infringements, and then following by the second part, we will discuss about enforcement actions, starting with getting to know who are the relevant authorities, following by the different measures in which the trademark owner could consider when there is a trademark infringement trademark infringement in Cambodia. So as we already understand from the previous speaker in relation to how to overcome the office actions in case of when they want to register a trademark, the trademark owner would like to know what are the trademark rights and then what could they do if there is an infringement. So what are trademark rights under the Cambodian law? Trademark rights are exclusive rights to use a registered mark in relation to the good or services for which it has been registered. So when we say exclusive rights, of course, they are the rights that exclusively owned by the trademark owner. And that means if any other person would like to use or need to use the mark, they need to have the authorization or the agreement from the trademark owner. And then when we say the use of a trademark, it is of course the use of the mark to identify the good or services in commercial world. It could be the act of affixing the mark onto the goods, or use the mark to identify the service, or use the mark on business stationery or advertising material, etc. Not only that, the trademark right will cover the use of exact same version of the mark on exact same version of good or service, which we mostly said the use of substantially identical mark. It does extend to the act of using the similar mark in relation to similar good that leads to confusions. And the example of this is, of course, when you use when someone's trying to use the mark Nuki, which is up here, in relation to T-shirt, while we already know that while we already know about the mark Nike, which is used for the shoe. So in this type of circumstances, although it is not exactly the same, it's still considered as an infringement. It could be covered under the trademark right of the owner of the mark Nike. However, please note that trademark right in Cambodia do not extend to the act in respect of the articles that have been put on the market in Cambodia by a registered owner or the consent thereof. That means the trademark right would exhaust upon the first sale in Cambodia. And when we say, when we talk about exhaustion of trademark rights, of course, we would think about parallel importation. So when we say like, okay, trademark right would exhaust upon first sale in Cambodia, that's just mean that parallel importation in Cambodia is not allowed. Then what constitutes trademark infringement? So the law on marks, trade names, and acts of unfair competitions does contain a provision that identifies what could be considered as an infringement of a registered mark, quoted under Article 24, subject to Article 12, which is about the validity of trademark. An infringement of a registered mark shall consist of the performance of any act referred to in Article 11, which is about exclusive right to use the mark by a person other than the owner of the mark and without the agreement of the letters. simply say it means that the use of a valid mark by any person other than the owner without agreement from the owner could amount to an infringement. The trademark law does contain provision about infringement of registered well-known mark as well as infringement of an unregistered well-known mark as well. And the difference between these two is that if it is a registered well-known mark, the infringement would cover not only the act of using the mark with respect to identical good or similar good or service, but any other goods that could lead to connection between the owner of the well-known mark and the owner of such a good, and that the interest of the owner of the well-known mark is likely to cause damage. And in the case that it is an unregistered well-known mark, the infringement will cover the act in respect to the use of identical or confusingly similar mark with respect to identical or confusingly similar good or service for which the mark is well-known only. And the example of it is that in reality, this Rolls Royce mark is a registered mark in Cambodia. And of course, we all know that this is a luxury brand for vehicle and spare parts. So it is obvious that this could be considered as a registered well-known mark in Cambodia. So if someone else wants to use this mark for a coffee shop, let's say, in order to sell a coffee, which although the coffee shop is not one of the business of the owner of the mark Rolls Royce, the owner of the mark Rolls Royce can still take actions or go against those that third party. But in case that this Rolls Royce mark has not been registered in Cambodia, but still it could be known for being a luxury brand for vehicle and spare parts, it would then be considered as an unregistered well-known mark in Cambodia. So if so, it would be protected against the use of the mark with respect to the vehicle and spare part only. And then it will not extend to those that are using it in respect of coffee shop. And that is why it is more recommended to register your mark in the jurisdiction in which you want to have a protection, because trademark rights, if of course the territorial rights. And the trademark law does contain provision on offenses. And there are several offenses under the trademark law, such as false statement, which could happen during the application or the filing of a consolidation action, etc. The act of counterfeits, manufacture or producing a counterfeit product that will be penalized by a fine as well as an imprisonment. And then the infringement with regard to the imitation of the mark that likely to mislead the public into believing that it is the mark of other enterprises, which is quite like an act of unfair competition or passing off, because it could come in two ways, like someone else is trying to copy your product but not your mark, or someone else is trying to make the mark that look quite like an imitation of your mark in order to be benefited from your reputation that you have already built. So in such a case, it would be also penalized under Article 65, which will be punishable by a fine of 5 million real, which is equivalent to $1,250 to 10 million real, which is equivalent to $2,500 and or a imprisonment between 1 month to 1 year. There's also an infringement that comes in the form of a willful import, sale, offering for sale of counterfeit product or the imitated product that will be punishable under the trademark law as well. And in case that the infringer committed and repeated offenses, they will face a double penalty. And please note that under the trademark law, the goods that violate trademark law shall be confiscated and or destroyed according to the decision of the court, regardless of whether anyone is convicted. Moving to the second part, which is about the enforcement actions. So we generally categorize the authority that could somehow work on trademark infringement matter into 3 types. The first type is the supervisory authority, which is the authority that provide the trademark registration, that handle trademark registration, as well as they have technical knowledge or background with respect to trademark right in Cambodia. And that is, of course, the Department of Intellectual Property Rights under the Ministry of Commerce. And the second authority is the enforcement authorities, which are akin to police officers. So this authority, we mostly focus on those that are that deal with the red actions or criminal action. For example, like the Anti-Intellectual Property Crime Bureau and the Anti-Economic Crime Police. So this bureau is responsible for planning and investigating into the infringement matter relating with relation to intellectual property crimes, including, of course, trademark matters. And the second authority and the enforcement authority is, of course, the Counterfeit Committee of Cambodia, which we normally call them CCCC, like C 4 times. So this authority is an interministerial committee that has been established in 2014 in order to deal with all kinds of counterfeit goods that are harmful and affect harmful to health and social safety in Cambodia. They also their mission also extend to the infringement of trademark right as well. And it initially consists of 11 representatives from different ministries and institutions. But until April 2022, their capacity has been extended to 28 representatives from different ministries and institutions, including the Ministry of Interior, Ministry of Justice, the Ministry of Health, so on and so forth. So because of this mixture of authorities, the Counter-Counterfeit Committee of Cambodia acts like a one-stop shop for right owner or the trademark owner in order to consider when they want to take actions against any infringement of their rights. And the last type of enforcement authority in Cambodia is those that have, to some extent, mission in relation to intellectual property, although their initial mission is not really about intellectual property. For example, the General Department of Customs and Excise. So this custom officers is known as the authority that have a broad mission to control the import and export traffic of the whole country. However, under the trademark law, this authority has been tasked with a mission to control matter in relation to IP infringement as well, and it comes in the form of suspension or clearance of the good that could be a counterfeit good. And lastly is the court, of course, which is the judicial authority, which is the judicial body in Cambodia, and that deals with all types of disputes, including trademark infringement. Talking about the measure in which the right holder could take, I mean, there are several strategies or measures in which they could consider, and how they could deal with it, or what are the steps that they have to follow would depend on the nature of the case. It would depend on the nature of the infringement, the scale of the infringement, who are your infringers, so on and so forth. So the list down here is not really it's not listed in order, because some of the action could, for some type of infringement, you just skip the first or the second and then go to the last one, or it depends on the matter of, the infringement matter nature, just like said. Okay, so let's say that these are all measures that you could consider, that the right holder could consider. The first one is the private enforcement measure, in which the right holder could take without involvement of any authority. And the second is the administrative proceeding, which is kind of like a mediation proceeding provided by the Department of Intellectual Property Rights, if we talk about trademark infringement matter. And the another measure is the border measure, which come in the form of suspension of clearance to be done by the custom officer. And lastly is, of course, the civil and criminal action, which is a stronger measure in which the right holder could take with respect, in order to deal with infringement of their rights. First of all, it's about private enforcement measure. So this measure, as I mentioned, it's does not involve any authority at all. So the right holder could initiate this measure upon receiving enough evidence to support that there could be an infringement of their rights. And by doing so, it also means that they are the one that control the whole proceeding or the whole process in order to lead to the settlement of the dispute. And that's also mean that it does not cost them much time or much money as well. It could, for this measure, it could come in the form of sending a letter, and the letter would be different depending on the tone that you want to use as well. It could be a stronger tone, a stronger message, which could be like the cis and desist letter, or it could use a softer tone like a cooperation request letters. And in case the infringement happened on the e-commerce site or social media platform like Facebook or Alibaba, the right holder could submit a takedown request to those sites in order to remove those infringing content. And they also have to submit evidence of registration in order to get the site to consider and approve the takedown request. And of course, in this proceeding, in this measure, there might be a negotiation, because after sending the letter, somehow the other party would want to talk to you or would want to talk to your representative in order to identify what are the things that they have done wrongly, or what could they do in order to settle the dispute, because they do not want to go further as well. Like we all know that the dispute is not it's not cheap, it's really expensive. So if you come to the first stage and then you negotiate and deal with it, it's like you are done, it's okay, carefree, right? And for this measure, it is the first measure that is recommended in infringement cases. And in our experience, most like around 80% of the case will be solved in this stage. And it's a lucky thing for the client too, because they don't have to spend much money on the dispute. Moving to the second measure, which is the administrative proceeding. So for this proceeding, we mostly recommend to the client when the dispute cannot be solved at the first stage, like when the negotiation failed. So this is the non-binding mediation procedure that facilitated by the Department of Intellectual Property Rights. It is a transparent and effective measure because the Department of Intellectual Property Rights would guide the parties throughout the proceeding. So in order to initiate this proceeding, you have the trademark owner will submit a complaint to the DIPR, and then after the DIPR review and consider the complaint, they might send an invitation letter to the other party to come for a hearing. And during the hearing, the DIPR will be the guide for each party to negotiate in order to reach the settlement. And at the end of the mediation proceeding, there will be a minutes in which the party have to sign, and it will list down some agreement that the party have agreed on, so that it's like a contract between the party on the agreement of the settlement. As I mentioned, it is a recommended measure for straightforward infringement cases that does not involve, that cannot be solved by the private enforcement measure. Next is the suspension of custom clearance. So for your information, I put it here does not mean, I put it here, but it does not mean that this is the third step after filing the administrative proceeding, because as it will depend on the nature of the infringement, how you would go with the state, and your lawyer would be in the best position to advise you which step they should take. But it's just the list, the simple list that you could consider each when you have a trademark infringement matters. So this suspension of clearance have been specified under Article 35 of the trademark law. Quoted, the owner of a registered mark may make application to custom or competent authority or the court to suspend clearance of goods suspected of being counterfeit by proving that he is the owner of a registered mark. As you have known, trademark law in Cambodia has been enacted since 2002. And that means this article has been in place since 2002 as well. But this procedure was not implemented because at the time, because there is no prescribed fee that have been defined to be defined. There's no application form and there's no guideline on security deposit for taking this measure. However, in 2022, the Prakas number 196 have been issued in order to enhance the effectiveness of the enforcement of IP rights by setting rules and procedure for suspension of clearance on all imported and exported of IP infringing goods. So that means this suspension of custom clearance procedure is now implemented, and it's now possible for the right holder to consider. And after the Prakas 196, there is also a guideline in order to put the implementation of such Prakas into place. So what is the scope of the Prakas 196? Of course, it would cover the rule and procedure for taking suspension of custom clearance with respect to imported or exported goods that infringe IP in respect of marks, geographical indications, copyrights, and related rights. That means, of course, it will cover trademark infringement, and trademark infringement will come in two ways, as I mentioned, like either the use of identical mark on identical good, which is, of course, the counterfeit, the act of counterfeiting, or the use of similar goods, similar mark on similar goods that could lead to confusions. Please note that this Prakas does not cover the transit good. I mean, it does not mention about transit good. So we are still doubt whether the Prakas 196 would cover the transit good that infringe IP right and coming through Cambodia or not. The suspension of custom clearance could happen in two ways. The first one is when the right owner, which is the trademark owner, file the complaint or initiate the proceeding by themselves. So under this procedure, it means the right holder the trademark owner file an application to the General Department of Customs and Excise and pay the official fee of 1 million real, which is equivalent to $250 US. As I mentioned earlier, like when there is a trademark law, they have not defined the fee yet. But right now there is an official fee that has been set, so it is possible to file the application. And along with the application, the trademark owner would need to provide information about themselves, information about their trademark rights, information about the suspected goods, such as the amount of the infringing good to be imported, who are or is the infringer, the checkpoint in which the good will be transported through, the mean of transportation, like which car plate or which shipment, and then, and of course, the reason to suspect that there is an infringement of their trademark rights. And the custom officer will then review the complaint. I mean, we'll then review the application, and if approved, they will suspend the clearance of the disputed shipment. Another action that could happen under these circumstances is when there's no complaint, when there's no application by the trademark owner, but the custom officer initiate on its own initiative the suspension of clearance in respect of the good when there is a prima facie evidence to support that the importation of counterfeit trademark good is taking place or is imminent, or when there is a reasonable ground to suspect such a things. That means under these circumstances, trademark owner is not the one that inform the custom officer that there could be some problem with respect to their trademark good or with respect to their trademark rights. The custom officer may initiate on their own, so they have, as long as they have prima facie evidence. And after they suspend the clearance under this proceeding, they have to notify the trademark owner, and then the trademark owner will have to inspect the good. If there are sufficient evidence to support that the good really infringed the trademark owner could initiate the court proceeding. But if not, the good will be released. For these two types, I mean the two circumstances in which suspension of custom clearance could happen, there need to be a payment of security deposit. The security deposit is required to be paid as an assurance to protect the importer, the consignor, the officer, the custom officer, I mean, as well as to avoid abuse of proceeding. And the value of the, the amount of security deposit could need to be 30% of the value of imported or exported goods. And if it is if the good is a perishable good, which are the goods that could be likely to be spoiled, such as counterfeit milk or counterfeit dairy products, for those type of goods, the additional amount would be required in addition to the 30% value. Such security deposit is required to be paid when the custom officer responds in writing to the application for suspension that they will suspend the good, or if the action is taken ex officio on an ex officio actions, this security deposit is required to be paid when the IP owner decide to bring the case to the court, because then they will have to suspend the good further. And lastly is, of course, the civil and criminal actions, which is the strongest action in which the trademark owner could take. For this action, they could consider filing a complaint to the civil court in order to seek preliminary injunction or to seek damage compensation, or submit a criminal complaint to seek enforcement of their right by enforcement authorities such as the Anti-Intellectual Property Crime Bureau and the Anti-Economic Crime Police, or via the prosecutor. Those authorities will examine the complaint and probably start to initiate the case or start an investigation into the matters. And then maybe they will conduct a seizure at the shop in order to gather the information, the evidence. And if there is an infringement confirmed, of course, a criminal complaint will trigger a criminal prosecution of the infringer, and the good will need to be destructed. And under this procedure, actually, there is an out-of-the-court settlement option as well for the right holder to take. That means before sending the case, they could reach an agreement during the proceeding in which each party agreed to settle the dispute and then drop the case. So the case will not have to go to the court, or there will not be a criminal prosecution of the infringer, but the good still have to be destructed. It is this measure is only recommended for serious infringement case, such as when there is a like sellers, importer or distributor or manufacturer of infringing goods. So I would like to share some successful cases that we handle in Cambodia, but we share it on a unanimous name. So firstly are the cases that we handle based on the by relying on the private enforcement measures. So for this dispute, it is a dispute between a global coffee chain and a local coffee shop that was using a confusingly similar name and logo. So after reviewing the matter, we decided that we should send a letter to the local coffee shop informing them about the client trademark rights and that what they should do next. And after sending the letter, the local coffee shop contacted us for a negotiation. And upon the negotiation, we discussed about the problems. And after that, it came to a settlement in which we convinced the other party to change the name and then run it under unique coffee shop name. Another case is a dispute between the global vehicle manufacturer and a vehicle repair shop that was using a registered mark without authorization. That means they try to use the logo of the clients on their shop in order to, advertise their service. So we decided to send them the letter informing about the client trademark rights and ask them to stop using, to remove the mark from their shop. But the negotiation was prolonged and failed. So we decided that maybe the next step is to file a request to ask for help from the Department of Intellectual Property Rights. So the Department of Intellectual Property Rights consider our request and then send an invitation letter to the other party to come for a hearing. During the hearing, the IPR facilitated the proceeding, And then at the end, we reached an agreement in which the repair shop agreed to remove the mark from the shop. Lastly, is about a dispute between an audio equipment manufacturer and an audio equipment store that sold audio equipment under identical and confusingly similar name and logo. So for this case, it means that that audio equipment store is selling, of course, counterfeit audio equipment and another, an equipment and the quite confusingly similar map. So we decided to obtain an official opinion from the Department of Intellectual Property Right with respect to the use of confusingly similar map. And we received positive results from the DIPR that confirmed that, of course, it is a confusingly similar map because the map consists of 3 letters, and then that store only changed 1 letter at the end, which is, of course, still lead to confusion. And based on this opinion, we decided to file a criminal complaint on the act of counterfeiting as well as the act of unfair competition, which is passing off. The complaint was filed to the Anti-Intellectual Property Crime Bureau to investigate, seize the good, and turn the case over to the prosecutor for criminal prosecution. After reviewing the case, the Anti-Intellectual Property Crime Bureau conduct a red action with the prosecutor, and then in which they found out that, of course, that store is selling counterfeit goods. They even have a tag or sticker that have exactly the same version of our client map, which means they are producing counterfeit goods. And then the goods have been seized for as an evidence of the case. However, at the end, we reached an out of the court settlement between the party in which we agreed to certain damage, and then the case has been dropped. So but the good has still have to be seized for destructions. This is the end of my presentations, and please drop the questions on the Q&A sections if you have.
Yes, we have had a solid 3 hours of webinar. And on behalf of APAA, I would like to thank the Department of Intellectual Property of Cambodia, as well as distinguished speakers from Cambodia, as well as from India, Indonesia, New Zealand, and Vietnam, to share with us a lot of information. I can see from the questions from the audience that there is keen interest in knowing more about how to register trademarks in Cambodia, how to enforce the trademark rights in Cambodia, etc. I'm very happy to say that our speakers have agreed to share the slides, and we will later on arrange for the slides to be published in the APAA website. So for now, we will close the webinar, but the trademark caravan will be moving on to another jurisdiction sometime later. So watch for information from us. Thank you very much, speakers. And thank you, Department of Intellectual Property of Cambodia. Thank you. Bye-bye.
Thank you.
Thank you. Thank you.
Thank you.
Bye.
Bye.